And I guess what I have to tell you up front is the bill will have an enormous, undesirable, probably unintended effect on a large number of tenants, thousands, potentially thousands of tenants, because what the bill does is it greatly expands the circumstances in which a landlord who is trying to remove an occupant does not have to go through the court process, and instead can sign an affidavit that effectively says this tenant isn't supposed to be there, and can be enforced by a state marshal without any form of due process whatsoever. And it's an open invitation. And again, I don't think this is intended, but it's an open invitation to allow landlords to avoid the eviction laws and simply get a third party to throw people out with none of the protections that go with it. The reason that this is difficult is my assumption is the bill's intended to be about squatting. But the problem is that it uses words in ways in which may be different from the meaning they have in the legal context. I think it kind of confuses things. It talks about tenants when eviction is about occupants, basically. Eviction law covers all occupants. If you live there, you don't get to get rid of people without going through the court process. Why would you make anybody go through the court process? Because that is the way you determine who is allowed to stay and who isn't. You don't have a marshal whose job is to evict people after a court has decided a case. You don't have a marshal just somehow having to figure out, do I believe the landlord? Do I not believe the landlord? Is this a tenant? Is this not a tenant? Is it a protected occupant? People don't understand, for example, you don't have to have a written lease in order to be a tenant. Thousands of Connecticut tenants occupy under oral leases, yet this bill says that if you're challenged and to prove that you have a right to be there, you have to you have to produce a copy of the lease. You don't have a lease. How can you make a copy of it? There are all sorts of ways. I mean, that's just one example, but there are all sorts of ways in this bill in which this bill assumes a kind of high-end tenancy in which people have all this paperwork, and if they can't produce it and the landlord claims they never knew about them being there, then they can be evicted without process. The process is so that the occupant can have a chance to argue that they belong there. If the way the bill is written, for example, it would seem to potentially put out people who are not immediate members of a family. So your roommate, your girlfriend, a live-in life partner. I mean, they're sort of defined out of being covered by the civil law with the rights that go with it.
Your 3 minutes are up. If you could please summarize.
Okay, well, it's from the perspective of those of us who work with this area of the law very closely. It is full of unintended adverse consequences, and that I understand it as an effort to try to solve a problem, but at some level, it's almost like it's a solution looking for a problem. The circumstances under which it would really apply are very, very rarely happen. But the way the bill is written, it will happen all the time. It will incentivize landlords not to use the process. They'll think they can get by that way. So I would ask you to take Section 1 out of the bill. I don't know anything about the rest of the bill, and I'm assuming the rest of the bill's fine. But Section 1's the problem, and we would ask you to remove that from the bill. Thank you very much for the opportunity to speak.
Thank you, Rafi, for joining us this morning. And thank you for your call and going through this language with me. We did try to define what the unauthorized person is, and the goal is really for the worst case scenarios of someone, having their house occupied by that unauthorized person and not gaining access. So we will definitely work with you on making sure that we address the concerns that you brought here today. Any other questions? Senator Marks.
Thank you, Chair. Thank you, Rafi, for being here, or Attorney Podolsky for being here. So this is just my chance to tell a little story, and you can agree. I had a patient who was very ill, and they lived in a not very poor section part of town. The apartment was not very nice. They were on a month-to-month lease. He had cancer, had a trach, couldn't talk. His sister came to help him while he was so ill. He ended up in the hospital for 2 weeks, so the sister stayed in the apartment, and the marshals were called, and they tried to get rid of that sister that was in the apartment. So I have seen these kind of situations, these scenarios happen where just people are really just out of luck and life is really, really hard, and they don't always have the language skills that we have or the knowledge, or their fear of power is different than maybe many of ours is. And that's what I fear with this bill, the way it's written, is that people in these kind of situations that already life is so difficult that they will end up losing where they are living. I've seen it happen firsthand more than once.
If I can say that, I mean, that's certainly one of the circumstances that would be a problem with the bill. But I think it's important for the committee to understand that when a tenant rents an apartment, the law calls it exclusive possession. They have exclusive possession of the apartment. The landlord may or may not know who's actually living there. But from a landlord perspective, it's like, I don't know who that person is. Why are they there? I never agreed to put them in. That makes them either allegedly unauthorized or unlawful. But it's not a crime for a tenant. Even if a tenant has a lease that says only you can live there, if you let somebody else live there, nobody's a criminal. The tenant may be in breach of the lease, and you can be evicted for breach of the lease. You actually have a right to cure. You can make the person get out. But you only can do those things if you have a process by which people have an opportunity to explain themselves. I guess I will just say I'm more than willing to work with you on anything. But part of what's a problem with this bill is it is built around the notion that you can do things with no process. And once you start, if you acknowledge you should have a process, then we have a process, and it's way faster than most people seem to think it is. And that's part of the difficulty in trying to figure out how you identify something like this. But there's just so many circumstances in which occupants essentially have a right to the process, and the bill takes the right to the process away from them, and then invites people who don't really have a good case to see if they can't get a marshal to implement that. And that's our concern. I mean, for us, it's a major, major concern that it will change the way in which the process works, and the process has been designed to be fair to both sides.
Representative Meskers.
So Rafi, we have met in many venues. Sometimes we agree, sometimes we don't agree, but I appreciate your knowledge base. So when we spoke before the meeting, from my point of view, and the questions were, people don't always have a 6-month or 12-month or 2-year lease. And I think, you commented that you thought that neither side sometimes benefits from a longer term lease because it's a financial contractual obligation for the tenant, which he's liable for if he leaves. And the landlord may prefer a month to month. So your interpretation of the bill now is that if I have a 1-month lease and the day after that lease expires, I'm no longer the lessee. And as an occupant, the way you view the bill is I would become an occupant subject to eviction the day after the lease expires because I can't produce a valid lease.
Well, no, that's not quite what I was saying.
Okay.
And I mean, this is sort of in fairness to the drafting of the bill. That's not really what the bill says.
Okay.
But
I'm just trying to ask what the details are. I haven't read fully the bill yet.
The bill, part of my concern is that will be the way it's understood by landlords. But that's not, but the bill doesn't recognize, for example, that there are many kinds of tenants. There's a tenant under a lease, under a written lease. There's a tenant under an oral lease. There are people who live there, whose status is what sometimes they're called common law tenants,
Right.
that you don't cease to be a tenant automatically. The bill tries to accommodate to that. So I don't want to say there's nothing about that in the bill. But in terms of the process itself, you cannot reasonably expect either a landlord without a lawyer or even a marshal to, in all cases, know those distinctions. And the reason they're not a problem now is because under eviction law, if somebody's living there, then you cannot skip the process. So it's routine and nobody thinks about it. The distinctions may impact how someone raises a defense to whether the landlord is entitled essentially to take the property back or not. But it's not, but you can have all these distinctions and it doesn't matter because they're all covered by the eviction laws. And if you look at the eviction statute, you'll see it in many places it uses the word occupant and not landlord or tenant. That's the core problem, is that people erroneously make distinctions that don't exist. It is not a crime to be in breach of your lease. It is not a crime for you to have admitted someone to live in your apartment with you, even if your lease doesn't allow it. You're not, the person's not a squatter because they're living with someone. Those kind of distinctions make a difference in how things function. And it is very, very hard to figure out how to write a bill that picks up all those distinctions. But in practice, I don't think it's a problem. And so by escalating the notion of it's a problem and then trying to address the bill to this minuscule problem, you end up unintentionally picking up all sorts of other situations that don't belong in the bill. And that's to me it starts from an assumption of a problem that is very, very minor. There are 20,000 evictions in Connecticut a year. That's a lot of evictions. And the system functions. People have a chance to be heard.
I just wanted to give you that time and get your nuances and understanding.
Right.
So I appreciate that. Thank you.
Thank you.
No further questions, Madam Chair.
Senator Wong.
Thank you, Madam Chair. And Rafi, thank you for your tireless and passionate legal services advocacy. As Representative Mesker said, I value your perspective. We may not always agree, but you mentioned the word squatter. As I'm reading through the language in Section 1, there are great efforts, as the good House Chair mentioned earlier, to kind of differentiate between tenants and squatters. There's a real effort to define the legal standing of individuals that are under question here. So you mentioned the word squatters. Tell me what the language definition and how do you interpret the difference between squatters versus tenant rights?
First of all, I don't think there is, and I don't think there is an official definition of squatter. So it's a layperson's term that's not necessarily defined. A typical kind of squatting situation might be somebody breaks in to a closed building, or maybe goes into a vacant building and camps out there. Typically, they're not actually living there in any meaningful sense of the term. I mean, that's sort of what people think of in terms of someone squatting. It's not based on I mean, there may be elements of acquiescence by the landlord or non-acquiescence. The landlord may or may not know about it. It may be there may be no permission from the landlord, but if you start talking in terms of who has no permission, there are hundreds, thousands of people that the landlord doesn't know are living in their property because the landlord, that's just the nature of occupancy. The landlord has leased at some point to somebody who's got the right to move people in, and it's not a crime for them to do that. It's hard to answer the question, frankly. I mean, that is the reason. I mean, in effect, what the bill does is it it turns people into squatters without using the term when they're not squatters. And in the true squatting situation, what's going to happen is people are going to get arrested. I mean, they're going to be told by the police you have to leave. But the police have, I think, wisely been advised, unless it's really obvious, tell people to go to court. If you have a situation that is obviously a situation with people who've broken in, then you will indeed arrest them. I don't want to encourage the use of police, and because that creates a whole nother set of problems. But I think that that when this kind of issue arises, it's addressed under the existing statutes. But what this statute does is it really encourages a process in which people in practice define as squatting everybody who's there without their knowledge or consent. And that's enormously overbroad.
Well, so I won't use the word squatter, and I appreciate the insight. So let's use the word unauthorized person, as the language states. And I think we're looking at landlord-tenant contract law, lease law, but it's very clear. Line 5 says unauthorized person is an individual's unlawfully occupying real property and is not a current or former tenant of the real property or immediate family as defined in section 1-91. Then others in regards to the sections here that unauthorized person is unlawfully entered and remain and continue to reside in such properties, that they're not in litigation. And line 19, such unauthorized person cannot produce documentation, correspondence, or identification cards issued by any governmental agency identifying such unauthorized person resides in such real property. So I'm just saying, let's not use the word squatter, but somebody who does not have a contractual lease arrangement that is residing in the property, and this bill is looking to remove these individuals that are unlawfully occupying a dwelling unit. So take me through that as an attorney. Where is that process for an individual that from a landlord's perspective, an unauthorized person occupying a property? What recourse do you think they have on a legal recourse?
Well, let me start with the answer, which is they can bring a summary process action. But you're really illustrating my point, and that you say, well, they need to show some documentation that they live there, but under Connecticut, under every law of every state, you don't need to have a written agreement in order to be a tenant. That, I mean, in the low income community, probably, I don't know, maybe a third, a half of the tenants don't have written leases. If you have a written lease that expires and with everybody's consent, you stay. I mean, it's the typical thing is your lease expires. Either the landlord offers you a renewal, or if he doesn't want you out, you just stay. All right. You're not occupying now under that written lease. You're occupying, it's turned into an oral month-to-month lease. If somebody says, in order to stay, because now the landlord wants you out, that you have to show that you have written documentation of the right to be there, you don't have, nobody, that you're not going to have the written documentation. I mean, ask somebody, show me a copy of your lease. I mean, you're a tenant. Show me a copy of your written lease. I don't know where it is. I mean, that's not a document that people necessarily carry around with them. It's
I understand that, Rafi, but former tenants.
But what I'm saying is, it's the fact that you don't have certain written documentation doesn't make you unauthorized. And if you're unauthorized, it doesn't make you unlawful. It's not when I say it's not a crime, that's what unlawful would mean. It's a crime. So you could be arrested for a crime, but that's not and there's a question, unauthorized by whom? Well, the landlord says, I never agreed to this person to be there. Somebody else was the person I rented to, and who's this person? I don't know who they are. Well, there are circumstances under which, I mean, like I say, you broke in, there's a crime right there. But that doesn't mean that there's something unlawful about the fact that the landlord doesn't know who you are. These are day-to-day issues with occupancy in buildings. And a landlord may have very different expectations or beliefs than the tenant does, but the law is clear. The law is that if you're that there's a process to determine if there are disputes, there's a process to determine, and that process is through the bringing of what we commonly call an eviction action. That technically the term is summary process. And that's done. It's done as a matter of routine. I said 20,000 a year in Connecticut. It's not like it's a big unusual deal. And this bill is going to create, I believe, a tremendous amount of misunderstanding, no matter how it's written, but misunderstanding by generating the belief that if you don't want to go through the eviction law, contact a marshal and tell him that that there's somebody in there and I don't know who they are and I want them out. You don't have to go to court. You don't have to do anything. That's not, I mean, we've spent a lot of time making sure that landlords understand you can't do that. And this bill is going to say, go ahead, take a shot at it. And that's going to be very disruptive to the process. And the less sophisticated you are, the more you, as a landlord, the more you're likely to get in trouble by doing this. I mean, you can get sued. The bill itself says you can sue people. Nobody's going to sue them because nobody's going to have the resources. They're going to lose all their property because under this, you're not protected the way you're protected with minimal protections in a court eviction. That's Senator Wong. That's why it just doesn't work. I guess that's what I'm trying to say to you. It sounds okay on paper. It just isn't workable to do it this way. And we have a system. It's not like the landlord has no remedy. Hundreds of landlords use the remedy all the time. The courts are very busy. So that's why I say it's not. The solution is significantly, enormously worse than the problem. I don't know if that answers your question or not.
No, I appreciate your thought, but I think you also kind of affirmed to me when you say you've handled 20,000 of these such cases.
I haven't. I haven't. No. I'm sorry. I'm not claiming I have. I'm telling you the courts.
No, but if you're citing that there are 20,000 such cases that are being raised either on an annual or through the whole process, then I would challenge that your statement that it's an answer looking for a problem, but there it is an issue. So I always appreciate talking to you, Rafi, and again, thank you, Madam Chair, for the opportunity to kind of have this engagement. So thank you very much.
Thank you.
Thank you. Senator Honing.
Thank you, Rafi, for being here. You had mentioned that there's already a process for people who are squatting in a in a building, a summary eviction process. Can you describe that and how that is sufficient?
I mean, I know I used the word squatting. Probably I shouldn't have used the word at all. There's a kind of trespassing, which is sort of what it's trying to get at, in which you might actually have police involvement. But the eviction statute is framed in terms of occupants rather than tenants. Tenants are obviously occupants, but there are people who are occupants that may or may not be classified as tenants. And it is a process. You can go to the housing court, and they have pro se forms for people who don't have a lawyer as a landlord that you can fill in to get a case started. And what that process will do is you start a case in court. If the tenant may not even respond, in which case you'll get a judgment by default. But assuming the tenant responds, it will lead to the court has mediators, and they will try and settle the case without it having to go to trial. Mediators in the housing court system settle about 90% of the cases. So it's sort of a winnowing process. You end up with a much smaller percentage of cases that would have to go to trial. If it goes to trial, then you're going to have a trial in front of a judge. And the judge will decide. And if the judge decides that the landlord is right and is entitled to take the property back, they'll issue a judgment. From a judge, you have 5 days to move after the judgment, and then you can get what, interestingly enough, is called an execution, which you give to a marshal, who is a neutral entity, and the marshal job is to go out to the property and remove who's ever in it, and they will do that. I'm guessing that if out of 20,000 evictions, maybe it used to be at least when we tried to count the number of executions, maybe 3,000. So maybe 15% of the evictions that are brought turn into actual physical removals by somebody. It's done in an orderly manner. If the marshal's worried that somebody's going to break into a fight, they'll have the police come out just to keep an eye on the situation. That's sort of the way it works. It's a faster system than virtually any other part of the court system. Way faster than small claims court, for example, which people think of as being a relatively fast system. The median time spent in court statistically is something like 37 days. So it's about a month from the time that you start the case in court till the time that a judgment enters, on average. Obviously, they're more, it's not as well as they're less than that, but that's sort of a ballpark number. I don't know if I'm answering your question or not. It's
Yeah, no, that's
ask me again if I'm not responding to what you want.
no, that was what I was looking for. Thank you. Thank you, Madam Chair.
Representative Meskers.
So just trying to get those statistics. So there's obviously, 20,000 is a lot of evictions and a lot of obviously tenant occupant disputes. But you're saying that roughly 90% of those are mediated and resolved and 10% end up in a judicial process? Is that
Well,
roughly the case?
end up in a trial. But I mean, it winnows down from the beginning. First of all, I'm not suggesting that that any significant number of those are the ones. The bill is not trying to turn those into unilateral, one-sided removals. I don't mean to suggest that's in any way the purpose of the bill.
No.
But the question I was trying to answer is if someone is there without any right at all, then what would the landlord do in that case? And part of the answer is the landlord, could bring a summary process action because one of the grounds in summary process picks that up.
I think you're addressing the bill, and I was more addressing the system right now.
Well,
So the question being right now, what I'm asking, and it's not
okay.
Advocacy or otherwise, it's informative. There's about 20,000 evictions, you said annually. Is that the number basically?
Yes. That's a judicial branch
And
could
we're
confirm that
talking
number.
about 2,000 of them end up in judicial versus.
No.
You said close to 90% are mediated?
Okay, let me take a step back. 20,000 of them end up in judicial.
Okay.
Okay, these are a case is filed. Yeah, you enter the case in the judicial docket,
Right.
and so they get a case number. They're a pending case. Probably 30 to 40% of them, the tenant will never respond. The tenant gets served by a marshal.
Okay.
The tenant will never respond. It'll end up in a default judgment. So you've just knocked out, let's say, 30%
Okay.
of the cases because they're going to move very quickly. Of the remaining ones, you now have a process. Presumably, the occupant will have filed an answer of some sort,
Right.
saying, "Here's my defense." Just like there's a pro se form for the landlord, there's a pro se form for the tenant.
Right.
In reality, most landlords have lawyers, most tenants don't. But anybody can use a pro se form. That will then lead to a scheduling of a hearing for which the parties are told, go see the mediator first. The mediators then try to work something out. A very common resolution is that the tenant agrees that they will allow a judgment to enter, and maybe they'll get a little extra time as part of that process. The large percentage of evictions are based on non-payment of rent. And so it's a fairly finite task to determine whether, number one, did they pay the rent or not? And number two, did they have a good, acceptable legal reason for not paying the rent if they didn't? I mean, that's what the judge decides if it goes to trial. If you mediations often work out compromises on those issues. So by the time you reach the stage of a trial, you've reduced the number of trials you're going to have to a much smaller number than the 20,000 cases that were originally filed. But the 20,000 are all in the judicial system, and people have a right to a trial if they want a trial. It's not like the landlord files an affidavit, as this bill would do.
Right. Again,
And
my question
okay.
wasn't the bill.
All right.
So
Sorry.
don't worry. I'm just want to get those numbers drilled into my head. So basically you're saying 20 or 30% when the process is begun, there's the tenant vacates in 20 or 30% of the time, or there's some resolution
Well,
when the claim is first made.
well, the tenant may or may not vacate.
Okay.
If they default, because the landlord is the plaintiff. The landlord has to file papers with the
Right,
court to
right,
start the case.
right.
The tenant, the papers will have been served on the tenant.
Right.
The tenant will be told that you have a certain date by which you must make a response.
Mm-hmm.
If the tenant doesn't, then procedurally the landlord moves for judgment by default and it's entered. The tenant may still be there. That doesn't, it's possible the tenant is moved. A lot of tenants default because they're already gone, but other tenants don't. They just don't respond to the papers. In which case, the landlord will still need to get a marshal to go out and physically remove the tenant.
Okay.
The other cases, the tenant is responding and saying, I want to participate, I want to be heard. And the court will then move from there. There'll be scheduling so that the tenant has the opportunity to be heard.
Okay. I kind of understand.
Am I getting there at all? Or
Well, 20, not to belabor, but so 20 to 30% reach some kind of a solution after the landlord submits the claim of the violation, right?
well, they end up there'll be a judgment.
Right. I'm saying, fine. So 20 to 30% get to
it-
judgment.
It's not a mutual solution.
No, but it's 20 to 30% get to judgment. What I'm trying to figure is how many get to mediation, how many go to a full trial or with the judge.
I don't have the exact. I don't have numbers on that.
I
And
was trying to figure
probably
out the scope of the scale of how the system is adjudicated currently.
okay. At any time, the tenant could move out,
Right.
and that will make the case moot.
Right.
So if the tenant leaves, then there's nothing to have a trial
Right,
about.
right,
There's
right.
nothing to mediate about. The tenant's gone. I don't know what percentage of tenants will have moved before you get to a point where you have to really respond. And I don't know if there's any data on that at all. Judicial will have data on the things that do happen in court, but they won't have data on the things that happen sort of in real life.
That get dropped, basically.
No, they'll have information. For example, I'm sure from judicial, you could find out how many actual trials are held. And I think it'll be a very small percentage of the 20,000 cases will end up in trials. But judicial is not necessarily going to, if you said to judicial, well, how many people physically move out before it gets to a trial stage, they're going to say they don't know because they don't know what happens outside the courtroom. If the case ends up being dropped, they don't know why the case was dropped. The case could be dropped because the landlord and tenant have privately worked out agreement. It could be dropped because the tenant has moved. I mean, there are any number of reasons you might drop a case.
Perfect.
So
Sorry.
there's limits as to how much data we can have. But what we know is that at some point in the process, if the landlord obtains the judgment and the tenant doesn't move, then the law allows a marshal to physically remove the tenant. And that's when you see pictures in the paper of people's stuff being taken out of the apartment and put out. And then there's a requirement under the law, the eviction law, that it has to be stored for 15 days by the municipality because to keep it neutral, to keep it from all through the eviction process, it's a buffered process. The landlord and the tenant don't confront each other directly. It's, in the court system means you've got a judicial process. Afterwards, you go through the municipality. But ultimately, but the tenant will be, the landlord has a system which is used to forcibly remove tenants, but it's not the kind of system that's in this bill.
Okay, I appreciate it. Thank you, Bradford. Chair, no further questions.
Great, Rafi. Thank you for joining us today. We
Thank you.
appreciate your testimony and look forward to working with you further in this.
Thank you very much.
Next up, we have John Souza, followed by Bill Gunnison.
Good morning. How's everybody this morning? Can you hear me?
Welcome.
Thank you. My name is John Souza. I am I volunteer as president of the Connecticut Coalition of Property Owners, and I'm a full-time landlord. The Coalition of Property Owners is one of Connecticut's largest property owner organizations around the state, with affiliates from one end of the state to the other. For over 20 years, CCOPO has been a constructive voice for responsible landlords on such issues as nuisance abatement, bed bugs, domestic violence, and many others. We're the local representative landlords of your small towns. Many of our members have other jobs, and we all know our tenants by their first names, and we know that our relationship benefits the tenant as well as ourselves. I'm here today in support of two bills. I'm going to start with the easy one. The first one I'd like to support is SB 1386. That's the act concerning dog breed and insurance underwriting and evaluating the feasibility of establishing a penalty for misrepresenting a dog as a service animal. CCOPO landlords urge the committee to include multifamily housing providers and clear language that emotional support animals are included as part of this bill. Landlords have dealt with this problem of getting penalized or canceled by insurers and having the threat of discrimination lawsuit held over our heads when we question someone's emotional support animal legitimacy. The internet is full of fake credentials for pets to become a support animal with merely a credit card needed to order it online and have it sent to your home. Most tenants do this tactic to avoid a pet fee or to live where no pets are allowed. I think that's a no-brainer for everybody. Being able to have some kind of local requirement for a doctor to write a note would be a simple way to solve that problem instead of making it outline and making insurance companies, if people do have these things, making insurance companies be forced to cover us. That would be one way to do it. Secondly, I'd like to support the first section of 7078. I have been listening this morning to Mr. Podolsky speak, who I know very well. And I would have asked him one question: if in the other committee they're trying to remove lapse of time, which they also remove no right or reason to live there, and then formally had a right, but that right expired. If they're removing those three clauses to do an eviction, if someone's in your property illegally, like they moved in when you're away for on vacation, or a seasonal rental that you go down to in the spring and there's someone living there, you have no reason to get rid of them. There is no tenant-landlord relationship. So these are the type of problems that this bill, I think, is aimed at fixing. If you have an empty house for sale, it's empty, and somebody forces their way in, Rafi says it's a crime, but half the time the police don't want to get involved. If somebody moves in some furniture and says, "Hey, I'll live here," I don't have a lease, but I got a receipt, and maybe they made it themselves. These are the type of examples when I think common sense needs to come through, and we should be able to, with the help of a marshal. I think marshals are state representatives; they're part of the law. They have enough common sense to determine whether or not someone is there illegally. And I don't know any tenants today that don't have any receipts, don't have any paperwork. Who can do business today without a cell phone, at least, to get text, to get paperwork, to pay their rent online? Anybody could show a rent receipt. They should have them all, right? They get paid if it's on paper. They get on paper if it's on through a portal, which most landlords use a portal type system do. So I'm asking you guys to support that bill as well. Take some of the aggravation out of being a landlord. Yeah. Thank you. Take some aggravation out of being a landlord. It's one of the things we can do to help control the costs of housing. Thank you. I'll take any questions.
Thank you very much for being here. Can you tell us how often you experience situations that you explained where people move into summer rentals or move into a property and move some stuff in, and they are unauthorized or unlawful in their being in a situation like that?
So in my instance, it has not happened to me specifically what you're referring to. I know some of our members that has happened to. A more common one would be somebody is a tenant. They tell me they're leaving. They've been my tenant for a couple of years. They return the keys and they vacate the apartment. We go to prep it and there's still somebody living there, and it's their friend who actually was couch surfing and doesn't want to leave now. So that's a very common thing. I've happened to me multiple times. Now the question is, under Rafi's explanation, yes, I could use the legal system against them. But again, I don't have a lease with this person. I don't know anything about this person. You know, they're not my tenant. They never filled out an application. They never paid a dime of rent. All I know is that there's somebody there. And if I don't have the ability to remove them, you know, that's not really fair to me. If I have to go through the eviction system, especially if they do away with lapse of time bill that they're talking about in the housing committee, it's going to make it even harder because I have no reason to evict them. They were never my tenant. This bill would help solve that problem. And when it's common sense, it should be easy enough to do. I don't understand why it has to be so hard. I don't think most landlords are going to be throwing people out because their lease is up and you know, they want them out of there. They have remedies in there for the tenants to go. There's plenty of money to be sought by the tenants to stop that kind of thing. People are going to think twice. We're only going to use it when necessary, is my opinion.
And there was a reference to, you know, if something like that happens, the police are called. I was under the assumption that the police do not like to get involved in landlord-tenant issues. Do you have any experience with that?
That is 100% correct. If, you know, if there's a dispute, if someone says, I live here, you know, here's my keys, the tenants, the police don't get involved for the most part. They're saying, this sounds like you have to litigate it. So they don't get involved. That's why I think in the bill, it says the state marshals are a branch of government, right? They're part of the government, like the judicial system. Most of them have enough common sense to read the law and understand what it means. There is penalties if the landlord does it unjustly. You know, the person would be able to go and get some legal aid. I'm sure they'd be all over it to get some money out of the whole deal and enforce their rights. Or worst case scenario, the marshal will say, well, this is too complicated. I'm not going to be involved. You're going to have to go through the eviction system. So, I mean, this happens pretty regularly, to be honest with you. People, you know, moving into places they're not supposed to be, friends of family or something move in. I mean, I've even heard of a relative moves into your house when you're away. So no, not your, you know, not somebody you know them, but they're just a relative, and you go away on vacation, say to help your daughter, or you had a baby, you're going to stay there for a month, and you come back and there's one of your relatives living there, and they're like, oh, I live here. There's rooms and stuff. You know, I got my furniture here. Here's my mail, you know. So now you're like, what the heck? I didn't give you any opportunity to move in here. We didn't agree to anything. There's no paper trail, you know, between us as landlord-tenant type of relationship. So, you know, this is what it's designed to solve. It's pretty narrow, in my opinion, as far as what kind of situations that would be involved in it. It's not going to just be, you know, my tenant's been there for 5 years and I'm tired of them. I want to throw them out. Their lease is expired. That's not going to fly. And I think any sheriff would understand, a marshal would understand that.
Thanks, John. In the situation where you were saying someone was couch surfing and you went to the apartment, and you have another tenant that's supposed to be moving in there, are you now supposed to go through you know, an eviction process and not collect rent and you know, and not have this person that you had already signed a new lease with? Like, what's the process currently for you know,
Right.
getting rid of someone that's there?
Yeah. So presently, if you can't talk the person out and the marshal doesn't, the police don't want to be involved, then you got to go through the eviction process. Presently, we have laws that say, you know, if they were never my tenant, they never had a right to be there, then I want them to leave. And I would go through the process, like Rafe said. If the person fights it, it could take 3 to 4 months. If they don't fight, it could take less. But the point is that, you know, I have no way of recovering expenses most of the time. And, you know, we're losing tons of money. It makes it harder, you know, expensive for housing. It's just one more hurdle that small landlords have to deal with every day to try to run a small business in Connecticut. It's hard. It's ridiculous sometimes, to be honest with you.
And just my last question, when I hear your stories, sometimes I think you could do things like take additional security deposits, you know, to mitigate against stuff like this. But are you capped on how much security deposit you can take from tenants?
So Connecticut, if you're under 62, it's 2 months. But let's be honest, and depending on where you do business, you can only collect what tenants can afford. I charge a month and a half. That gives them incentive to, even if they use the last month to pay the last month's rent, they have an incentive to keep it clean. But you know, I'd love to see 3 months, but I don't think a lot of tenants could afford it, and I wouldn't be able to collect it anyway. So, but with somebody that's credit marginally, 3 months would be great. That would give me an opportunity to consider renting to them.
Thank you. Any questions? Senator Marks.
Hi, Mr. Souza. Thanks for being here, and thank you, Chair. So I'm Chair of Housing, and as far as the lapse of time goes, we are doing in the Just Cause bill, we are doing a year lapse of time, so that will give the landlords a year to be able to evict somebody without cause. So that has been addressed. And I mean, you know, we all say there's, you know, there's good landlords, there's not so good landlords, there's good tenants, there's not so good tenants, and that's humanity, and we all agree with that. But is there the other side of the coin, other stories that what you're saying, where maybe the landlord is getting rid of somebody like I don't know if you heard the story I gave before Attorney Podolsky spoke when I asked him a question, that sometimes the landlords are trying to get rid of people that maybe they just don't like, quote unquote, by saying that they're quote unquote squatters, and that there is a process in place already to get rid of these unauthorized tenants. So in reality, we don't really need this part of this bill. If you could just speak on that.
So I think I understand your question. You're saying there's already a system in place to take care of this thing, which is true, absolutely, to a degree. If it's cut and dry, clear that somebody broke in, we all agree that the police should come and arrest them. I think everybody would agree that and take them away. But what if it's not so cut and dry? What if you're gone for a month or 2 or 3? And you come home and there's somebody living there and they have bills in their hands because they put the internet in their name or whatever, the gas bill, you know, then it's not so cut and dry. Then you're going to have to go to court. And that's a problem, I think, for a lot of instances. What if it's your home and somebody breaks in and takes it over while you're not there? I don't see it as being that hard to solve with a state marshal involved. If it's too complicated, they're just going to bump it up to the regular court. But if there's somebody in there and if there's any kind of question, you know, whether they have a landlord-tenant relationship at any point, I don't see why this wouldn't work, to be honest with you.
Okay, I just think that there's always that that one situation that's very far-fetched. I mean, I don't know how many people actually come
course.
on vacation and somebody's if I came home from vacation and somebody was in my house, I think I would call the police, and I'm not sure it would be too difficult for me to get rid of that person.
No, I agree.
Right. So I just think we have a process in place, and I think we have to be so careful because sometimes it is the person is there and they are legally there, and that is their home. That's their shelter. That's their roof over their head. And we're talking about shelter, which is about as important as food, right? You need food and you need shelter to live. And I think we have to be so careful when we pass this type of legislation that we make sure we really protect the people that are seeking shelter and that are doing it legally, and that sometimes their landlord just doesn't quote unquote like them. And I agree that sometimes really bad things happen and people can be awful. But I do believe that there is a process in place. And I just don't know how many times we really have this crazy scenario like you state. I mean, I think it would be interesting to see how often it really, really does happen. I appreciate
It happens more than you think. I'll be honest with you. I know a bunch of lawyers that deal with it. It's usually sometimes it's a relative that shows up. Sometimes it's a seasonal home. It's very common. Or somebody, like I said before, is couch surfing is in the property. It's very common, actually.
Okay, I'm all set, Madam Chair. Thank you.
Thank you.
Thank you, John. Next up,
Thank
we have
you.
Bill Gunnison, followed by Rachel Bard.
All right, good morning, Chair Wood and members of the committee. My name is Bill Gunnison, and I'm the Legislative and Regulatory Counsel for the Motor Vehicle Protection Products Association. And I'm here this morning to testify in support of Senate Bill 1425. MVIPA is a national trade association representing providers, retailers, administrators, and insurers of vehicle protection products. A key part of our mission is to promote consistent regulatory framework across states to eliminate confusion about the regulatory status of vehicle protection products. These products, which are sold primarily by auto dealers, include agreements to do things like repair and replace tires and wheels, remove dents or creases from the vehicle, repair windshield chips or cracks, repair interior rips or stains, replace key fobs, or provide benefits to consumers if their vehicle is stolen. This bill would establish that these kinds of agreements do not constitute insurance. Roughly 46 states have made that determination, and this bill would add Connecticut to that list. And by affirming that vehicle protection products are not insurance, the bill ensures that consumers will have access to valuable coverage that traditional auto insurance may not offer. In many cases, even when primary insurers do provide coverage, high deductibles and the risk of increased premiums can make filing a claim impractical. And it's important to note that the bill includes consumer protections like disclosure requirements that ensure consumers receive clear information on how to do things like file a claim, access benefits, and cancel agreements. And there are also financial assurance requirements that ensure that providers have the resources to cover claims. The last item I want to address this morning is that we do not anticipate that this bill will require the insurance department to expend any additional resources. As such, Section 2 regarding the assessment of fees, we do not believe would be necessary for the passage of the bill. I'd be happy to discuss any implications this may have on the department further. I look forward to working with members of the committee on this bill moving forward, and I encourage you all to support Senate Bill 1425. Thank you for your time.
Thank you, Bill. So who would be regulating these products?
So it would be sort of a combination of the insurance department and the Attorney General's office. Currently under this statute, the insurance department is responsible for confirming that contractual liability policies that are issued to back vehicle protection products, the insurance department confirms that those insurance companies are qualified to issue contractual liability insurance policies. And the Attorney General's office would regulate any violations of the statute, violations of the disclosure requirements, or anything like that.
So if the Department of Insurance is regulating these products, wouldn't that also mean that customers would be able to use the Consumer Affairs Division to file any complaints?
Customers would be able to use that Consumer Affairs Division to file complaints. That's correct.
So that would be time and energy used on the part of the department, and you are saying that they wouldn't be using, they wouldn't be expending any time and energy. I mean, I'm hearing two different things here.
Well, so in the event that there were complaints filed, then yes, they would need to spend time on that. But the bill doesn't impose any additional regulatory responsibilities or anything like that on the insurance department.
But when they are using their time, someone needs to cover that. So I'm just confused as to why you wouldn't support the assessments. Just like if the insurance department is regulating any, industry, they are getting assessed. So you feel that you shouldn't get assessed?
Well, actually, I feel like I would like to have a conversation in more detail about where the department expects to have to expend resources and have a more in-depth discussion about that. The Section 2 wasn't part of the bill that was brought last year, and so it would be really helpful to have more in-depth conversation about that at some point moving forward.
Okay, so I have no issue with regulating these products for the benefit of consumers. Just going through the data, there's a lot of people that are purchasing these. The Department of Insurance is a place in this bill that we've said would be the regulatory arm. And in essence, there needs to be an assessment to pay for their time. So that's why the bill has not moved forward in the past, is because, the department needs to be compensated for their time. So we set up a compensation mechanism similar to other products. So we would definitely need to work with you on that language and understand your further opposition to it. Any other questions? Representative Meskers.
Yeah, I'm expecting going forward, if we go anywhere on this bill, that I'm going to be looking at the insurance department also to make assessments about how effective the pooling of risk in the sale of this product is. You purchase these products essentially to cover your risk, right? So there's a pooling of risks. They are expecting you're expecting so many claims, you're expecting so much profitability out of selling the product. And I'm expecting that there's a reasonable amount of payout going on in the product. It's the way we regulate insurance, the way we pool risk. Now, this may not technically fall as an insurance product, but it is a risk mitigation and pooling of risk, which is why people buy it, because it's cheaper it should be cheaper than the replacement cost in the open market, because you've shared the risk of chipped windows, bent fenders, etc. So at some level, whether I call it insurance or not, it's a risk mitigation product. And the people who are best set up to make the assessments, both in a regulatory and oversight view, are people who are involved in the insurance industry and our commissioners. So I would expect that we'd have to be able to do some kind of an assessment so we can monitor the effectiveness, that we're not selling people promises that aren't delivered on in terms of the payouts, and that the products are properly regulated. The more things I create that look like insurance, smell like insurance, and walk like insurance that aren't insurance make me uncomfortable. Thank you.
Any other questions? Bill, thank you for being here. Next up, we have Rachel Bard, followed by Sally Zenger.
Good morning, members of the committee. My name's Rachel Baird, and I'm an attorney in Rocky Hill, solo practice, and I've been practicing since 1992. I actually submitted 3 pages of written testimony, which I don't intend to repeat here. I just wanted to meet the committee in person and let them know that I'm available for any questions about House Bill 7068, an act concerning court-ordered countings of common interest community financial records. According to the brief description of the bill, this bill would allow unit owners of common interest communities to petition the Superior Court for an accounting of an association's financial records. I personally support this bill because of circumstances that I have observed in my practice. Going back to 2023, there arose a situation in a Rocky Hill condominium community where it came to light that the property manager was charging $95 per hour for labor, when in fact the contract said $65 per hour. This raised a red flag on the part of my client, who was a unit owner there, and he asked for an audit of the situation, because to him and a lot of other people, one red flag means there may be other things going on as well. He requested records, which the property manager never provided to the board. The board never responded to my client in terms of doing an accounting, and the wagons were circled among the board, the association council, and the property manager to make my client into the bad guy. Other things arose during the last 2.5 years that also brought concerns to light. There was self-dealing on the part of the property manager where he owned a company and all the business went to his company. There were no bids, there were no contracts. He owns an insurance company and he switched from the insurance that the association previously had to the company that he owns that gave out the insurance. Fortunately, my client was able over the course of time to point out these situations to the unit owners, and he gained enough proxies to turn the board completely on December 12th, 2024. 6 members were voted out with his proxies and 6 members were voted in with his proxies, and he remained the sole 7th member from the old board to the new board. And the property manager is out. Unfortunately, we still haven't received the records that we need for an financial accounting. We don't know if the property manager has them or if he just will not give them up to us. Now, in 2024, having been frustrated with not receiving the records that an accountant that we personally hired, we personally gave a retainer of $10,000 to him. When I say we, it was me on behalf of my client, Steve Pedno from Manchester, who is a nationally renowned forensic accounting expert. And he is standing by ready to conduct an audit, but he has not been given the records that would allow him to do so. I went to court. I filed a bill of discovery, which is a pre-litigation action where you can go to court and say to the judge, I need these documents to know if I have an action.
Your 3 minutes are up. If you could please summarize.
Thank you. We were not seeking money. We were only seeking the records. But unfortunately, a unit owner in Connecticut whose interest is the same as the other unit owners cannot bring an individual action. He lacks standing. Only the board can bring such an action. And if the board is unwilling to bring the action and the property manager is unwilling to release the records and the association attorney is sticking with the board, it leaves unit owners absolutely no redress when they identify financial improprieties. And I thank you. And as I said, many more details are contained in my written testimony.
Thank you, Attorney Baird. So can you just, kind of walk us through how this bill would be helpful in the situation that you described?
I did do a 50-state survey of other jurisdictions that have similar bills, and they are Maryland, the District of Columbia, North Carolina, and Massachusetts. And their bills give unit owners the right to have forensic accountings. Some need 5% of unit owners to come on board. One needs 33 and 1%. One needs only 1. So it varies. None of them mention, though, court intervention. And what I see wrong in their bills is, okay, I have the right to do an accounting. That's great. But what if nobody will give me the records? And Mr. Pedno from Forensic Accounting in Manchester has explained this to me over and over again. I'm here. I can't do anything without records. And the invoices that this property manager kept had no time and materials. It had no number of hours worked. It had no labors. And that's why nobody knew for over 2 years that he was charging $95 an hour instead of $65. It was my client's wife that discovered it when she started asking questions about a $440 bill to replace weather stripping on a door that should have cost probably about $30. So that's what led to this whole situation. How would this bill help? It would help for me to be able to go to the court and say, we've tried to get all the records we're entitled to under 47-260. They're not giving them to us. So we're going to need to go deeper. We're going to have to go into tax records. We're going to have to go into contacting these workers to see if they were in fact employed by this company and not being paid under the table. We're going to have to follow up on all these things that are going to require the court's intervention to do that we just can't accomplish on our own. So that's why this bill would help.
And the bylaws, is there any language around what bylaws should look like with these associations? Because I feel that I'm just playing devil's advocate here that, why aren't the bylaws set up to have this sort of protection in it so that the unit owners have access to transparency and records? Is there something that we should be addressing there as well?
The bylaws provide all these protections for unit owners. They're not followed. For example, the bylaws in this community said anything over $3,000 as an expenditure by the property manager has to be approved by the board. Not once in the 3 years that this property manager was there was ever any expenditure approved by the board. This board didn't even have signing access to be able to go to the bank and say, what's going on with our account? I'm telling you that property managers have experience and boards do not. They're volunteers from these communities. The knowledge of experience and the level of knowledge that property managers has completely overwhelms board members. They're intimidated often. And it often seems like unit owners and board members are seen as prey and property managers are predators. How is it that when it's $28 basically per unit for a property manager to be paid over the course of a year, which in a 168 unit complex would be about $60,000. How is it that that property manager made $250,000 off of that property in 1 year? How is it? Why? Because they self-deal the business to themselves. They use their own company, that's an insurance company, to sell insurance to the property. And none of this is legal. 20-459 specifically says self-dealing is illegal. It still happens though. It happens. So I don't care what the bylaws say. I don't care what the declaration says. I don't care what the law says. If the board doesn't make sure it's followed and the association attorney doesn't make sure it's followed, then the only redress we have is the courts. And I have a story. So one would say, oh, well, associations are represented by attorneys. Okay, well, I've dealt with association attorneys and they say, well, we represent the board. I mean, we represent the association, but the board speaks for the attorneys. So if you have a board that's not following the law, I asked one of these attorneys, I said, what is your obligation when a board's not following the law? No answer, never got a response. I found out in the past couple weeks that the association attorney for this Rocky Hill complex represented the property manager in a personal action against the property manager's wife, where he owed $18,000 for a business completely unrelated to this community. So you have an association attorney who's representing the property manager personally while he's trying to negotiate a settlement deal for the overcharge of $95 versus $65 an hour, which, by the way, this attorney didn't bring in an accountant to look at what was owed to the community. He negotiated it personally with his property manager, who he had represented privately the year before and didn't tell anybody about it. Now, the problem with all this is I have devoted hundreds of hours, hundreds in the past 2 years, because this situation of taking advantage of unit owners has so made me passionate about this issue. And my client, Ed Peruta, who lives at this condo complex and is on the schedule later to talk today, he's retired. He's 100% disabled, PTSD, Vietnam veteran. He has hours and hours to devote to this, and he got over half of the proxies of a 168 unit condominium complex. The problem is unit owners in other places are probably not going to find an attorney like me who has a close relationship with Ed, who's going to put in hundreds of hours. They're not going to find somebody like Ed who has basically all the time in the world to follow up on this stuff. None of these things would have been discovered but for the time that Ed and I had. And I'm not saying we're heroes. I'm just saying we couldn't help ourselves once we found out about this overcharge, and that nobody on the board, the association council, had any intention of doing anything about it.
And how about paying for the audit? How can you just walk us through how that would happen?
The 4 other jurisdictions that I looked at, they do make it a common expense for the community. We went out and paid a retainer of $10,000 to Mr. Pedno to get started on it. He's used about half of that so far. My client told the board, I'll pay for it. I'll pay for it, because he knows that once it's done, there's going to be evidence that a lot of money is owed to this community. I think it would be fair. I like the protections in 7068 that says, listen, it's kind of like a medical malpractice action. We don't want every unit screaming for an audit every time they get unhappy. So what we're going to say is, before you bring a medical malpractice action, you got to get a letter from a doctor in the same field that says, yeah, I see that there might be some negligence here. So in this case, I support this bill where it says you have to go to a forensic examiner, not just any accountant. Somebody does forensic accounting, and they have to say, okay, based on what I've seen, based on what I know, I can see something's going on here that would warrant looking into this further. You present that to the judge. You certify yourself that you believe something's wrong here. And you say to the judge, this is what the expert says. This is what we say. These are the records. This is what we've seen. Please, can you order these records to be disclosed so my accountant can do a forensic account? I hate to say that the owner should pay, because fortunately, Mr. Pruda is in a position to be able to do that. But there may be other unit owners in other communities that are not in the fortunate position that Mr. Pruda is in. It's not in the fortunate position I've been in, where I can devote hundreds of hours to something like this. And so I worry about that. So I think it should, to a certain extent, be a common expense. But on the other hand, I do know that there have to be safeguards so people are not just bringing these kinds of actions and the communities paying for it when there's no basis for that. So it's almost like, well, could the owner take the expense to begin with, because he'd have to get an opinion from the accountant? And then once the accountant weighs in and says, yeah, there's something going on here, then it becomes a common expense. And one other reason it became a common expense is because this condominium complex has an end of year audit every year. Now, this is not a forensic audit. It's just basically you look at the superficial things and say, okay. And so this accountant did that in 21 and 22. When Ed brought to his attention what was going on with the financials, this accountant still has not signed off on 21 and 22, and he refuses to even do 23 and 24 until a forensic audit is accomplished. So there. So now this complex has to have a forensic accounting, because they're not going to get any accountant to sign off on an audit ever again if they don't, because this accountant has said no. If they try to go to another one and that accountant finds out what this accountant said, and that accountant will find out, nobody is ever going to sign off on this. So under those circumstances, yes, it's a common expense now, because it's a common issue that an accountant that does the end of year audits will not sign off on it.
Well, thank you for saying that. We do need to kind of work through some of this, because
Yes.
I did get an email this morning from a board member saying that this would deplete their association funds. And I think we need to I mean, we get hundreds of complaints in this topic every year. A lot of it is like inactive associations, poor bylaws, not following bylaws, lack of training on the board members, because it's usually a volunteer group. So we just need to make sure we think about all those things and get those opinions on this legislation as it moves forward. But we certainly hear you and want to do something, to help protect these unit owners, because people are busy living their lives. They're not necessarily thinking, hey, I need to be active in my association, because it takes a lot of time and energy. So we appreciate you being here. Any other questions? Representative Meskers.
So I understand that you're looking at some level for support for an individual unit owner's action, which is not supported by the board at this moment in time.
It is supported by the board. The board changed on December 12th, 2024. And so it is now supported by the board. And the board, in fact, has to do it, because the accountant says, I'm not signing off on anything until you do it.
So the issue for this particular issue is resolved in that manner currently.
I'm going to say no, because I am purely speculating, but I believe that when the condominium community, the board, hires an accountant, and it may very well be Mr. Pedno, since he's familiar with the situation already, that Mr. Pedno will say, we need these records. And I do not think, based on what has already occurred, that we can assume that the property manager is going to turn over the records.
Okay.
And I believe a court order will be necessary to make him do so. This is a property manager who, when he left, took out $167,000 in reserves that were in a CD and $62,000 in reserves that were in a Webster bank account, and used them to pay in whole the insurance premium that he procured through his private agency.
Good.
This is a property manager who refused to ever turn over invoices that show time, labor, materials. So I believe they will still need the intervention of the court.
Okay. So there's a question of intervention of the court and to secure records. I guess the other part, when I look at this structurally, the issues are that either both the accountant and the legal counsel for the board, at some point, maybe the issue is that they aren't required, or they don't certify that they're in compliance with their charter, or they do certify and then and it's erroneous. Because if there are safeguards within the agreement, there should be legal counsel and the auditors for the association should be issuing a compliance statement at the end of that. So it puts them at some risk or liability. That would seem to resolve a good portion of the risk. Where I'm concerned about individual action, it has to be very prescribed.
Yes.
Individual action, because you can see any unhappy unit owner out of 168, was it, or 160?
168 units.
168 units, you can easily find one or two gadflies on spurious issues, dragging the entire situation into a contentious issue within the board. In this case, we had, from what I hear from you, we had a turnover in the board to resolve the issue, and now we want to secure documents. But if you're asking structurally the issue of empowerment, it may be a question of how do we enforce that the audits are signed off on, and that the legal counsel for the board certifies they're in compliance with their board statutes.
Okay, so attached to the 21 and 22 audits that were presented is a compliance statement that someone on the board or their representative, association counsel, is supposed to sign off on for the audit to be complete. 21 and 22, nobody signed off on it. The old board didn't sign off on it. I don't know why. I do know that before the new board came in, the old board quickly entered into a $25,000 settlement with the old property manager for the overcharges, where we think the settlement should have been in at least 6 figures.
Right.
And then they presented it to the accountant and said, look, all the issues are resolved. You know, that Ed Peruta told you about this overcharge, but look, we settled with them and it's solved. And the accountant said, no, because this is something that's red flag enough to make me think there are other red flags there. So, you know, bylaws, declarations, if no one is following them, it's very difficult for a unit owner to seek redress. And as I said, I know that in one of the other jurisdictions, it requires 33 1/3% of the units to be on board. Another, it says the majority of units would be beyond 50. Anything is better than nothing, because a year ago, my client started collecting proxies. My client, his wife, and 2 other unit owners, they collected proxies over 50%. And my client is responsible for the board turning over in December 2024. And so, you know, even if you put it at 50, even if you put it at 60, it's better than nothing, because it might take time to convince unit owners there's something going on. But if you have the hundreds of hours that me and my client did, you can do it. I just worry about the complexes where people don't have the time that me and Mr. Peruta do.
Okay, thank you very much. I think you've answered my question. Thank you, Madam Chair. I just wanted to understand the process.
Great. Thank you, Attorney
you.
Baird. We appreciate your testimony today.
Thank you.
Next up, we have Sally Zanger, who I've been told is being replaced by Giovanna Shea.
Hi, I am on the internet. Can you all hear me okay?
Yes, we can.
Thank you. Good morning. Thank you for your time. I'm Giovanna Shea of Greater Hartford Legal Aid. I am testifying in opposition to Section 1 of HB 7078. That is removal, an act concerning removal of unauthorized persons. I want to follow up on and amplify a number of points made by Rafi and also respond to a few things that Mr. D'Souza said. If you look at Connecticut General Statutes 47A 23A, A1 deals with summary process when a rental agreement or lease has terminated. A2 and A3 deal with summary process when an occupant never had a right or privilege or right or privilege terminated. So Connecticut already has a summary process statute, and typically landlords and landlords attorneys, when they bring a summary process matter, will also bring it against John and Jane Doe. Sometimes my clients are like, who are John and Jane Doe? And that is to ensure that they can get an execution of the judgment against anyone who remains in the unit. But there has been this opportunity for due process and for tenants to come forward and say, actually, I do have a right to be here. Mr. D'Souza said, oh, well, I won't be getting rent during this process. Well, there is a procedure in the court for the court to order the person to pay what's called use and occupancy during the tenancy, or during the eviction, rather. We're extremely concerned regarding a potential for abuse if a landlord can just give a marshal an affidavit and have someone removed from a unit and do an end run around summary process. One of the situations we're very concerned about is folks who have just an oral agreement month to month, as Rafi said. For Greater Hartford Legal Aid, among our right to counsel clients, that's in excess of a quarter of the people, our statistics show. It's about 26% report having just an oral agreement. It's very common in the city of Hartford, in other lower income communities, to have an informal agreement. We also were very concerned about potential for abuse with out-of-state landlords who want to buy a building and they just want to clear the building. They may not have a really good rent roll. They may not have a lot of information about the people who live there. They may never come to the building. One of my colleagues from Connecticut Legal Services emailed me this morning. I was looking for examples, and she said, I had a tenant who lived for decades in the building. He always had an informal agreement, right? And an out-of-state corporate landlord operating out of a shell LLC purchased the building, and now they are going through the eviction process for never had a right or privilege terminated. He would be vulnerable to this kind of procedure if it were implemented and abused. Luckily, we still have summary process. They're going through the process, and he has the ability to say, hey, actually, yeah, I had a right or privilege to be here. I'm a month-to-month tenant. We're
3
very
minutes are up. If you could please summarize. Thank you.
So this is an end run around Connecticut's existing summary process statutes. We also see those examples where there's a caregiver or someone who remains in the unit. Tenants need and occupants need to be protected by due process, and we are asking you please not to pass Section 1 of 7078. Thank you.
Thank you, Giovanna. Can you just further explain the John Souza's point that he would not get rent if he was taking someone through the eviction process that was there
Sure.
unlawful? Just walk us through the cure for that, because I'm not aware of that.
Sure. So in the summary process statutes, there is a procedure for getting reasonable use and occupancy, is what it's called. Rent is the legal term for when there is a tenancy, and use and occupancy is what is generally paid when a lease agreement has terminated or was not in place. So the court can have a hearing and set reasonable use and occupancy. And then if the tenant fails to pay, they have to file their answer and go to the hearing immediately. And as Rafi explained, that is always in court, preceded by court annexed mediation before the parties see the judge.
Thank you. Any other questions? Thank you, Giovanna.
Of course, thanks for your flexibility this morning. Bye-bye.
Anytime. We have Darren Pruslow, followed by Dave Pillen.
Good morning. Thank you for letting me speak. My name is Attorney Darren Pruslow from Legal Center, and we work with veterans around the state of Connecticut. We are a civil legal aid organization. And I submitted some written testimony, but I just wanted to sort of highlight a couple of pieces touching on both what Giovanna and Rafi have said. There already is a process, and that process is working. And it really is designed to take into fact all these various considerations. Even in the proposed bill, which I'm opposing Section 1 of HB 7078, it does speak to, well, if it's done improperly, we have this. One of the things that has not been addressed, and I think for attorneys, it's maybe slightly more apparent in this, is that the federal Constitution requires due process before someone can have a property right taken from them. And possession is a property right. So if they do not actually have that property right, the process is going to go pretty quickly. But there still needs to be a process. Summary process was written and designed with all of this in mind. The reality on the ground is we've heard a couple of stories of these situations where there is this like people who are working between forcefully entering. There is criminal options for that. Not that we're looking for that to be the case, but for my population I work with, which is mostly veterans who either were homeless or are homeless, they're not forcing their way into buildings, right? We are trying to get them into shelters, into processes, and to work on chronic homelessness. Some of the requirements of this bill are not even requirements under summary process. So we're creating an alternative process with different requirements that actually don't make sense. Some of my tenants and my clients pay zero in rent because they're disabled, have limited income, and their voucher pays their rent. So they wouldn't have any rent receipts. Hopefully they have their HAP contract. Some of them are getting case management by VA social workers. So those pieces are all there, and they wouldn't be able to meet this piece. I have a lot of respect for the work that our marshals do, but I think our marshals would say the same thing. They are not judges. And the reason why the marshals can do their job is that someone else has already reviewed and looked over the process. We also have concerns is that property ownership does change, right? And Giovanna mentioned corporate out-of-state landlords come in, buy a property. The way the bill is written, that current owner doesn't necessarily know who these people are and could get the benefit of the bill as the way it is written. My argument is not to go over the fine-tuned pieces of this bill, because I feel this bill is trying to replace what already exists under 47A. And there's been a lot of thought and process into that. The other piece about lapse of time and sort of the changes on the just cause eviction, it's not removing lapse of time. It's just that certain people have a protection in certain circumstances. So one-off small buildings are not even going to be thought of under that bill.
Your 3
and
minutes.
I think that is my time.
Yeah, thank you.
Yes. I'll take any questions if there are any.
Thank you very much for your time. I don't see any questions. Thanks for joining us.
Thank you.
Next, we have Dave Pillen. Did I say that correctly? Is he here? We can come back to him. Is Greg Kirschner available? Dave, are you there? Or Greg? Greg, you can go.
Good morning. Thank you. Thank you for the opportunity to testify. My name is Greg Kirschner. I'm the Executive Director of the Connecticut Fair Housing Center and an attorney. Like my colleagues that testified before me, I'm here to testify against Section 1 of 7078. Try not to reiterate what's already been said, but basically, this would be an exception to the summary process rules that swallows the system. Adopting this policy would expose the most vulnerable of our fellow citizens who rent to risk, uncertainty, and exploitation. There are many fully legally protected but poorly documented tenancies and occupancies, home shares, rooms for rent, oral agreements where tenants will be at risk of losing their homes, their possessions, and even their freedom, because for some folks already involved in the criminal justice system, a mere arrest could lead to incarceration again. At a minimum, even if we don't get that far, it appears to potentially criminalize or at least give a landlord a veto over having house guests. It creates the opportunity for landlords to weigh in and decide whether you can have your significant other over, whether your grandma can come stay for a week, whether you can have a house sitter or a babysitter if you are going to be away. The remedies under this law to provide relief for someone improperly displaced provide no relief. They would require someone who has been forced out of their home improperly, who may have lost all their possessions, who are now homeless, who may be trying to find a roof to put over the heads of their children or to get them to school, to file and prosecute a civil suit, which will take time. The relief to restore them to tenancy will occur when and how? What if the unit has already been re-rented? Is that new tenant now unlawfully occupying that unit and can be put out by a marshal to restore this originally improperly displaced person? This creates another avenue where landlords can discriminate and can exploit tenants who can least defend themselves and least face the risk of loss of their homes. I listened earlier to the testimony of someone from the landlord group. Connecticut is a well-ordered and pleasant state to live in. What he described sounded more like the plot of one of the Purge movies of people taking over people's homes and not being able to be put out. That's just simply not the case of what happens. There's a system to address it. When we talk about squatters, there is no definition, but there are plenty of tools that have been described already to address that issue. And I would be happy to answer any questions that you may have.
Thank you, Greg, for your testimony. I don't see any questions, but I thank you for being here.
Thank you.
Next up is Dave Palan.
Yes, I apologize. I had trouble getting admitted. Hopefully everybody can hear me. I'm on.
Yes, you're good.
Thank you for your time today to the committee. I'm testifying today in opposition of Raised Bill 7068, which in its current form would allow a unit owner of a common interest community to obtain a court order forcing the community association to retain an independent third party to conduct an accounting of the association's financial records at the expense of all unit owners upon the suspicion of a possible misuse of the association's funds. It's my opinion that this bill is likely, as it's currently constructed, to do more harm than good and has a lot of unintended consequences that may not have been contemplated when it was drafted. I'm an independent insurance broker. I have about 20 years of experience, 20 plus years of experience in the condo and HOA, homeowner association industry. I'm a member of the Legislative Action Committee for the Community Association Institute's Connecticut chapter, and I represent over 500 community associations throughout the state. First and foremost, the threshold for approval of 10% of unit owners to trigger this review is very low and will allow a small minority of unit owners to initiate an audit. The Common Interest Ownership Act requires a 20% vote simply to call a meeting of unit owners, so the 10% threshold is very low. I've seen the types of claims that result from disputes like these, or even personality conflicts, and this could easily could be an easy lever to pull for a few disgruntled unit owners who have somewhat of a vendetta against a board that may be acting perfectly when it's within its purview. My colleague, Attorney Greg McCracken, will be speaking later to other inconsistencies of this bill relative to the Common Interest Ownership Act. But from my perspective as an insurance professional, the secondary impact on insurance costs to associations affected by this review can be significant and long-lasting. Associations can choose to cover the costs on their own, but situations where there are associations accused of financial malfeasance often escalate and can lead to litigation and in turn an increase in claim frequency, which will ultimately or can ultimately lead to non-renewal of their policies or certain lines of business. We already have an environment where obtaining affordable insurance is a significant challenge for community associations. And this legislation, if enacted, would invariably lead to an increase in claim activity, specifically with respect to the association's fidelity bond and or directors and officers liability policies, the latter of which has a relatively small pool of carriers available in the state. So it has the potential to cast Connecticut in a more unfavorable light from an underwriting perspective for these lines of business. It would likely increase the cost of insurance for residents statewide. And as a former board president of my own homeowner association, will likely have an after effect of discouraging owners from volunteering, knowing that the threshold for this level of scrutiny is so low. Conceptually, I certainly do not disagree with the need for sound oversight of community association and property manager activities. However, I do not believe that this legislation will effectively accomplish this task, and in some cases stands contrary to existing statutory guidelines already in place within the Common Interest Ownership Act. So with that, I respectfully urge the committee to reject Bill number 7068 or amend it to raise the threshold and criteria necessary to trigger a review. And with that, I will take questions.
Thank you, Dave. I definitely understand your view, but what kind of recourse would you suggest for these tenants that have suspected fraud against the property managers?
Well, again, I'm speaking from the insurance standpoint, from the legislative legal standpoint, the Common Interest Ownership Act has the thresholds necessary for a review. Even to call a unit owner meeting, it's 20%. So let's stick with what the statute already says and go with the 20% threshold. I'm just concerned that 10%, if you're talking about a community with 20 units, so 2 people can cause a forensic accounting review, that's pretty significant. And the accusation of malfeasance isn't taken lightly, which is why I believe that this will lead to an escalation in claim activity and legal activity, that this has a domino effect that I'm concerned about. That's my issue. And 10% seems to be a really low threshold for this level, the degree of seriousness of the accusation.
Okay, thank you. Thank you for your comments. I don't see any other questions. Thank you.
Thank you.
Next up, Frank DeFelice.
Good morning. Can you hear me?
Yes, we can.
Oh, great. Good morning, distinguished senators and representatives. My name is Frank DeFelice, and I currently serve as the chairperson of the Regional Planning Commission for the Lower Connecticut River Valley Council of Governments, RiverCog, and as the chair of the Planning and Zoning Commission for the town of Durham, Connecticut. I'm here this morning to speak and express my support for HB 7078, an act concerning removal of authorized persons from real property, which would allow owners of real property to seek and quickly remove unauthorized persons from their property. This is sensible legislation with respect to property rights and public safety. The longer an unauthorized person remains in a property, the more damage they are likely to cause. Do suggest removal of lines 25 through 27 regarding pending litigation.
Thank you, Frank. Do you have any specific stories you'd like to share with the committee?
Well, I certainly could. I mean, there are numerous accounts of where someone's come home, someone else is in their home, or maybe they go on vacation, they come home and their property is occupied. This is a public safety issue. This can escalate quickly. It's really important that this bill pass, if only for that section that deals with the removal of unauthorized persons from real property. It's a common sense bill. It isn't extensive. It could actually be more extensive, but it is not. So I do hope that you will consider its passage.
Thank you, and thank you for your perspective.
Thank you.
Next up, Brian Mezik.
Good morning, Representative Wood, Representative Barry. My name is Brian Mezik. I'm a Connecticut State Marshal. I represent the marshals across the state, and the State Marshal Association of Connecticut, AFSCME Local 2193. I'm here to testify on Raise Bill 7078, I guess what's being called the squatter bill, even though that term doesn't apply or appear within the bill. I put in written testimony, several reasons raised from our members why they're concerned about this bill. I won't read my testimony. I encourage you to read it, but I'll just highlight a few things. This is landlord-tenant and occupancy of property is a highly dynamic, complex area of law. It's an area of law that even the landlord-tenant attorneys and the landlords, don't think fully appreciate about removing someone from a property. So just by way of introduction, I know there was some discussion before about how many evictions there are and how many executions are issued. I've probably removed under an execution, a court order, well over 1,000 people. These are challenging, difficult situations. But in that scenario, it's issued by a judge where there's been an adjudication on the issues and there's a judgment. What's proposed under this bill would create probably what is the most powerful legal writ in our legal framework in Connecticut. So everything else is issued by a judge, or in some instances, like a writ of attachment for money, commissioner of superior court. But all those remedies and the enforcement is always under judicial review at a hearing, and there's due process rights. So I won't belabor that point about the due process. Also, this would sort of create a second track for a lot of these cases. And the way it's drafted, it appears that you could use this procedure for anywhere where there's an oral lease because it would be in dispute. The people want to be able to prove they have a written lease. So that's something that should be adjudicated in the courts. And I sort of surmise, I haven't talked to the judicial branch extensively about it, but there's something called entry detainer, which is a process where if there's an illegal lockout, the tenant or occupant can go into court and ask to be put back in. I can imagine that a great quantity of removals used under a procedure like this would turn into entry detainer actions, and you'd be right back in court anyway. So we would urge the committee to reject this bill. I'm happy to answer any other questions you have, and I encourage you to read our testimony because there's several other things we're concerned about in there.
No, thank you for that. And thank you for coming before our committee again. It's good to see you. Are there any room for improvement with this language? You've heard kind of both sides. We are hearing both sides. Is there any way to kind of resolve, I think, the worst cases of?
It seems that what's trying to be solved is the true squatter situation. I could be reading in between the lines here. I would say you got to keep it in court. I don't want to go completely off the rails and stay within the parameter of the bill, but it seems like the true squatter is what's trying to be solved here. I don't know. You could keep it in court. You could create an expedited scenario to go through court. What we need is a court order, because this would make us sort of the direct instrument of the landlord. Now, while the landlord pays us for our under an execution, we're ultimately working for the law and under the court order, and we're paid a set fee. So really, this is there's a couple causes of action to bring an eviction, like non-payment, lapse of time. I think this is never had a right or privilege to occupy, perhaps the true squatter. So if some sort of expedited process could be made in court, that is possibly a discussion. But to create a legal writ issued just on the affidavit of a landlord raises all sorts of issues. And I like being a marshal. I don't want to be a judge.
I definitely hear what you're saying and appreciate that feedback. I think it is, always looking at the worst case scenarios,
right?
And really trying to, you kind of have to be the boots on the ground, like you're doing every day, to give us that feedback of, why there's issue with this, and we appreciate that. So we'll definitely continue working with you and others on if there's a path forward here at all. So thank you so much.
You're welcome.
Next up, we have Eric George, followed by Greg McCracken.
Representative Wood, Representative Barry, members of the Insurance and Real Estate Committee. My name is Eric George. I'm president of the Insurance Association of Connecticut, here to talk about something other than landlord-tenant law, but I've been very interested in all of the testimony that's gone on so far. Here to talk about flood insurance, specifically Senate Bill 1385, which the IAC strongly supports. This would have the state conduct a study of not only the available options for folks in terms of flood insurance, but what other things folks should know in terms of public awareness of flood risk and flood insurance accessibility. I would be remiss if I didn't thank you, Representative Wood, for pulling together an informational hearing last month, actually a couple months ago, I think it was in January, where we really discussed flood insurance at a very deep level. And it's something that I think has really been a long time coming. We are seeing an increase of convection storms and an increase of their frequency and their severity. We know where it rains, it can flood. So even properties that are elevated can be subject to water coming in from the ground that cause flood damage. Hurricane Helene showed us a 500-mile swath of damage that dropped about 40 trillion tons of water, which is still a number I have a hard time getting my head around. Approximately 90% of all U.S. natural disasters involve flooding in some form. And the unfortunate reality is that folks are unaware that their homeowner's insurance policy does not cover flood damage. And they're also unaware, unless it is required in their mortgage documents, that there is a federal program created in 1958 called the National Flood Insurance Program to provide them insurance. And it is mandated if they live in flood zones, directed or defined by FEMA. But I would encourage folks, anybody who's listening, and it's something I say quite a lot, even if you're not in a flood zone, consider buying flood insurance. Water does not know the boundary that FEMA drew on the map. Water can infiltrate and damage property anywhere whenever we have a high significant storm. So we're looking at what I would say is not a great picture. It's sort of bleak because we have a known risk, and that's flood. And we have folks that are not aware of the availability of protection, and that's flood insurance. So we strongly support what this bill is aimed at. We think that public awareness is critical in this area. I mean, the state of Connecticut has undergone numerous public awareness campaigns, whether it comes to buckling your seatbelt, not drinking and driving, not going down the wrong way on an exit ramp. All of these things became critically important. And I would say that for the protection of property and where we see convection storms headed in their frequency and severity, flood insurance there needs to be a greater awareness of its availability. And folks who are not in flood zones, I've said it before, really need to consider purchasing it because water doesn't know the boundaries. I'm happy to answer any questions.
Eric, thanks for your testimony. Thanks for your help with the flood insurance forum. I know all of us kind of hate doing study bills, but this is a warranted study bill. And I think you hit the nail on the head. We probably need to put some money behind it. Why aren't people, I mean, with the cost of homes, why are people not putting the maximum amount of insurance coverage on their homes that now, I mean, I don't even know what the average home is worth in Connecticut, but you know, it's people's nest egg. It's how they're putting their kids through school. It's, you know, their retirement plan. Why wouldn't we have a huge rush to put flood insurance on, considering all of the storms that we've gone through? And what do you think the study, you know, is going to come out with? Is it going to be an awareness plan? Is it going to be educating the public? What is your, you know, perspective on that?
You're talking about, for many folks, it's their number one greatest asset that they have. If I could answer the question why people don't properly insure, I would be very happy to have that knowledge. Because one of the things that I completely do not understand is not all people, but some people, when they're free of a mortgage and they own their home outright, There are people who don't maintain homeowners insurance on their dwelling. There are people who, in the violation of the law, get into a car and drive without auto insurance. And there are folks who have not purchased flood insurance. Why they do that, I can't answer that question. What I'm hoping the result of 1385 is going farther than what we did 2 months ago, to understand that everyone in the state of Connecticut has access to the National Flood Insurance Program's coverage. That if you want to go above and beyond the $250,000 limitation in those policies, there's a private market that you can access. That if you live outside of a flood zone, your premiums are going to be much lower than you would if you're inside of a flood zone. So I think that it is high time, as we all see where storms are going, that this gets a much greater amount of attention. So I think if I were to look into a crystal ball, this study will look at what is available and then what is the uptick of people buying flood insurance, and you're going to see that it is woefully low. And so what I'm hoping, and we would very much like to be a part of this, the IAC, so I'm saying it here, I would like to be a part of this study and this effort to collaborate with the state, with the Department of Insurance, with the governor's office, with everybody. How can we increase the knowledge base of Connecticut residents about the risk and what they can do to protect themselves?
Yeah, I agree. I think we should elaborate the study a little bit more, make some more homework for our friends over there. But yeah, I think we should look at the barriers to entry. What are the hurdles? How can we mitigate that? How do we educate, more? I mean, what we learned in that informational forum is that relatively inexpensively, you can have, flood coverage. And I can't tell you how many, you're living this every day, but many constituents over the years have asked for my help with the Department of Insurance and their insurance coverage because they didn't have flood insurance and they wish they had. So we want to be a partner in this and try to do the right thing going forward. And as always, thank you so much for your advocacy in this space.
Absolutely.
Great. Next up, we have Greg McCracken, followed by Dr. James Carden.
Good morning. I am doing this by Zoom. Can everyone hear?
Yes, we can.
Okay, great. Yeah, I'm the secretary of the Connecticut chapter of CAI, or the Community Associations Institute, also a member of the LAC, or Legislative Action Committee. So here on their behalf this morning, I am speaking in opposition to Raise Bill 7068. I am an attorney. I have represented mostly community associations for more than 20 years. Probably in total, I've represented well more than 200 of them and have had quite a bit of experience with this. As near as I and my colleagues can tell, this really is a bill that's looking for a solution when there's no real problem. The problems are rare. This morning, we've heard about one association and one manager that were violating, it appears, existing laws that cover both associations and managers, and trying to find a way to remedy the situation in a way that I think will burden existing associations significantly and make them a lot less able to meet their financial obligations. Audits, simple ones, usually cost close to $5,000. Forensic audits can cost 2 or 3 times that, even more. It's not an insignificant amount. And the way the bill is written, I think it's just really too low of a threshold to force that kind of a requirement on community associations from such a small number of unit owners. Mr. Pilon did mention the threshold, 10%. It takes 20% just to get a meeting, unless the bylaw set a lower amount. I think that 10% is just too low. Beyond that, I noted in my written testimony that the threshold from a CPA or a forensic accountant is just that there appears to be evidence of fraud or financial misuse. I think that's too low. I think there needs to be a reasonable certainty. I think there needs to be a reference to actual facts that would indicate that, rather than, well, we took a look and there appears to be. That is not going to be any significant protection from unwarranted audits in these situations. I'd also like to see language that the Superior Court can exercise discretion if it gets a petition and an exhibit from a forensic accountant or a CPA saying we should do this. So it's not just a ministerial action. The court can examine what's being requested and whether it's appropriate. Beyond that, I would also, and I believe this was mentioned, like to see the petitioning owner bear the costs of the audit. Access seemed to be more the question in terms of records than getting the association to pay for something the owners want. If that's really the case, I think that the access is the critical part. If the forensic audit is going to happen, then it should be at the expense of the petitioning owners and potentially any of the other ones that supported the idea in going to court in the first place. Beyond that, I'd note that the resale certificates that associations have to issue have to state whether an audit was done within the previous 5 years or other type of accounting review. If they've done it, I think that should provide some sort of a higher hurdle or a safe harbor for whether they should be subjected to this bill. And ultimately, like I say, I think it's just going to have a lot of unintended consequences, a lot of expense from potentially very small groups of unit owners in a few communities. And we might be much better off better enforcing existing laws or providing better means of enforcement. So with that, like I say, I submitted written testimony. I will be happy to take any questions.
Thank you, Greg. I was just going to ask you if you submitted testimony. We will certainly consider some of your recommendations for the bill. But just to push back a little bit, we have gotten hundreds of complaints over the last few years, and this type of request and statute change came from probably a few dozen of our colleagues. That's why we're hearing it today. So we very much disagree with your assessment that there is not an issue here. There's a major issue. And our colleagues are asking us to have a hearing and to do something because current law isn't working. So, but that being said, we have no, we're not firm on this language and are looking for ways to improve it. So as long as you submitted public testimony, we will definitely be taking in to account some of your requested changes because we'd be happy to have you at the table.
That would be great. Can I speak to just that anecdotal information that you mentioned?
Sure, please.
I can tell you as an association lawyer, I see countless pieces of correspondence where the attorney general, the state rep, the senator, whomever, they're just copied on the communications. And if you dig into what's going on there, typically it's a misunderstanding of how the board works, a misunderstanding of the law, wanting somebody else to kind of fight the fight when either they can't or they won't do it themselves. But under Kiowa, the Attorney General, DCP, no other state officer or agency is responsible for enforcing it against the people that are subject to it. It's really just something that unit owners or other affected people have to do. And we're not New York. We're not one of those states where there is an entity in place that polices the whole thing. So I think that frustrates people. And then other times they don't realize that managers are actually subject to Chapter 400V that DCP enforces. And there are a lot of requirements there already that would apply to these types of problems. And they can make complaints to DCP for enforcement action, which in my experience can be quite effective. So I think education and just better enforcement of what's already there would go a long way.
Okay, well, thank you for those comments, and I look forward to working with you further on this. Appreciate you being here.
Great, thank you. Appreciate the opportunity.
Next up, we have Dr. James Carden, followed by Edward Peruta.
Good morning, Representative Wood and Barry. I'm Dr. James Carden, Senior Advisor, Hartford Healthcare, and very much appreciate the opportunity to provide testimony on HB 7116, an act concerning insurance accountability and transparency. To begin with, regarding Section 1, we have serious concerns regarding the prohibition of revenue neutrality clause in our commercial contracts, ensuring that a commercial payer cannot unilaterally change a contract clause that impacts the negotiated financial terms that were agreed to creates the potential for financial disruption and impact the provider's ability to remain stable and predictable over the course of a multi-year contract agreement. Those changes should and do occur during negotiations, and we feel that's the appropriate place, not in the intervening segment. Regarding section 2 and 3, if you would allow me, the cost growth benchmark was developed by Governor's Executive Order number 5 to monitor healthcare spending growth across all payers, public and private, with the goal of developing mitigating strategies to address the affordability of healthcare and improve health outcomes for all residents. OHS collects data to measure total healthcare expenditures and determines the annual rate of growth of healthcare on a spending on a per person basis. The cost growth benchmark target is based on a blend of gross state product and median income. To date, the results of this work have been disappointing. We are supportive of the purpose of the executive order. However, thoughtful evaluation of the current initiative, we believe, is warranted. In its current state, either because of insufficient data or inadequate analysis, we are unable to identify the current drivers of total healthcare expenditures. There are multiple contributors to healthcare spending: the age and disease burden of the population that are receiving care, the complexity of the care and provided and in what settings, the interrelationship of payer source, Medicaid, Medicare, which do not generally cover the cost of delivering that care, and the commercial payer that requires commercial payers to cover the cost to ensure providers have financial stability. This often results in upward pressure on necessary and good faith negotiations with commercial payers. Barriers to access of care, which result in delays of treatment and more expensive spending. There are multiple social influences that result in significant challenges for patients to receive timely care. Lastly, the cost growth benchmark is based on growth state product and median household income and does not account for the significant increase in cost of providers to provide care. These include the pay increases for clinicians and the incredible staff that are responsible for the exceptional quality and safety of the care that's delivered to state of Connecticut residents, the rising cost of supplies, pharmaceuticals, and purchase services, all of which exceed the current cost growth benchmarks that are determined. If we're serious about working together to mitigate total healthcare expenditures, we need to understand the drivers, develop strategies together. We don't believe that's possible in the current state. Appreciate the opportunity to make these comments and happy to answer any questions that I can be helpful with.
Thank you, Dr. Cardin. Can you just explain to us about the revenue neutrality provision? And again, just reiterate your opposition to that and why.
Sure. So our understanding of the revenue neutrality is basically somewhat of a hold harmless, that if the commercial payer decides to make a policy change or change the terms of a negotiated agreement, that they can't be held accountable to ensure that that does not have a significant financial impact to the provider. So oftentimes, and appropriately, a payer may change a policy within their the contract year, but that policy change can impact millions of dollars that the plan had originally agreed to pay for a service or a procedure that is now potentially at risk. If there's no ability to ensure that they can't make that change unilaterally, then potentially all of the agreements that were put in place to allow us to plan and go forward in terms of what we expect in terms of revenues based on the contract agreements are now somewhat at risk. So all we're looking for is that if there is a policy change that is going to have a significant financial impact on the previous agreement, that we need to have a discussion around that and make sure that that it does not result in adverse consequences. Typically, those kinds of issues are addressed on each each time we come back for negotiations to ensure that if there are significant changes that want to be made to the underlying paying agreements and the agreements we have, those changes happen during negotiations, not in the intervening years.
Thank you for that. And just to ask one step further on that, if the revenue neutrality provision was saving money, for example, if the payer found a way to reduce costs Are you saying that you've already budgeted for a certain number based on the contract and that would be difficult for you to recover, or are you not able to pass those savings on?
Payers always had the ability to put in the benefits design ways to further save money, and that's not what we're talking about. This is not a benefit design that we're going to narrow a network or something along those lines. What we're talking about here is, and I'll keep it simple, we've agreed to pay you to do certain services. We've now decided that we don't want to pay you for doing those services anymore by a policy change. The service is still going to be provided, but we're just not going to pay you for those things. That needs to be discussed to figure out why we're making that change during the intervening years going forward. The reciprocal of that is that nobody would agree that providers can suddenly change the price of their services during a contract year. So that just like they can't suddenly say, we're going to reduce your payments for these kind of things arbitrarily on their side, we don't have the ability to go back and say, hey, we're just going to charge you more for certain things. I simplified that a lot to just give you the example, but there are a multitude of policies that come through that have financial impact that we need to discuss because those policies were not in place when we negotiated the agreement, and they have implications financially for what we depend on in terms of understanding our revenue from that agreement during the time of the the entire contract year.
I understand what you're saying, and I think that this language was added, more to encourage savings and be able to pass that on. So I think there's definitely room for, discussion on this, and we appreciate your comments.
I agree with that. I think it's awfully broad is our concern is, and we didn't, we were trying to understand what the potential implications are, but I think further discussion is always healthy.
Okay, and then also I'd like to work with you on the cost growth benchmark audit. I think that this was very vague language and deserves a lot more detail in that. This request has come from, a couple years of informational forums and public testimony on the concerns, on a willingness of everyone to improve the cost growth benchmark. I mean, we all want it to be working in our favor, but to make sure that we are putting the data and interpreting the data and working with the data in a way that makes sense of our healthcare spend. So would love to get your advice on how we can improve that process. I don't know if you have any now, but letting you know that we'd like some better input on that, because I'm not 100% sure this language works.
Really appreciate the opportunity, and I think just some initial thoughts is one, I think this is a perfect time to come back and review it. It's several years into this process. We've learned a lot over the periods of a couple of years. I think the intention is still extraordinarily valuable and important for us to go through. I do think it's my only suggestion is broader than an audit of current data. I think that what we will need to understand is, are we getting the data we need to actually get to the outcomes that we aspire to in the original and what the governor put forward in his executive order? We need to have more detail in order to really understand what are the causes of the increased spend. It is not just price, negotiated rates, which is what we anchor on a lot in our discussions in these things, because utilization and the complexity of care that's being delivered is an enormous contributor to the overall spend. And there's a big difference between price increases and expenditures. So I think there's a real opportunity to have a great review and see if we can make this process better.
Great. Look forward to working with you on that. Thank you. All right. Next up, we have Edward Peruta, followed by Ryan Lutrerio.
I'm getting old. Chairman Wood, Chairman Barry, I'd like to thank you for this opportunity, and for the people that aren't here, I don't have a written testimony. I'm going to see if I can give you as much information in 3 minutes as possible. The difference between myself and my attorney, Rachel Baird, is this. The property manager's name is Daniel Zach. His company is Metro Property Management out of Glastonbury. In September of 2021, he was interviewing to be our property manager and made a statement answered based on a question, how much are you going to charge us per hour for those things that really aren't in the contract? He said $65 per hour. The former president heard it and said she wrote it down. The former secretary heard it, said she wrote it down. My wife Lois was on the board. She heard it. She didn't write it down. And a Dan Lynch, who was the former president and a member of the board at the time, said he heard it and he had an email trail of the $65 offer. In mid-2023, I was the treasurer. And as the treasurer, I started asking questions. One of my questions went to Attorney Baird. I said, Rachel, I'm seeing things I don't like. I need for you to explain to me the fiduciary responsibilities of a treasurer. What am I responsible for? What am I supposed to do? She explained it to me and I began to ask the questions. There was a board meeting and it was, let me back up. So prior to a meeting, the board gets a packet. And in the packet, there are invoices from the property manager to the board. In our situation, the work was completed. The invoice was created. The invoice was paid, like from this desk, it was created to this desk, it was immediately paid. And then a month or down the road, it's given to the board. The board never had a chance to see it before it was approved and before it was paid. But what stuck in my head was, it would say, repaired the weather stripping around the door and the door sweep, $430. Now, I married a very wealthy woman, and she used to work for her father in Philadelphia fixing apartments. So she's a good mechanic. And she said, $430, that's highway robbery. So I began to ask questions. And that's when the $95 an hour came up. And I said, why 95? I thought it's 65. So at the board meeting, when I mentioned it, I had the president and the secretary. Oh no, it's 65. I said, ask him. They asked him and I've got a recording of this. He said, oh no, it's $95 I've charged. I couldn't work with 65. So I charged 95. In preparation for litigation, I had to go through emails. And I found an email from the president to Dan Zach, dated September 9th, 2021. And it said, Dan, here is the contract with some minor changes from our attorney. And the attorney is attorney Charles Chaz Ryan, who I guess is the president, that lawyer that was up here opposing it.
Your 3 minutes are up if you could please summarize. Sorry.
Excuse me?
Your 3 minutes are up if you could please summarize.
I'd like to ask for a little bit more time.
Yeah, I can ask you some questions so that
Okay.
you can extend your testimony.
let me
So
just-
can you
let me-
please, can you finish your summary of this and we'll ask
The
you
email to
questions.
Dan Zach said, here is the contract. Please review it and tell us if you need any changes, okay, to the contract. He didn't say it has to be 95, it can't be 65. When I found out that it was 95, I said, Dan, I need to know how many hours you have billed Westage condos since October 1st, 2021. He has to this day refused to give me those records. We voted on January 10th unanimously to send Attorney Chaz Ryan to the managers, to Metro, and say, please obtain the financial records and bring them back to us so we can do this. He went down there and negotiated. And so I said to him, I said, Attorney Ryan, do you know the difference between obtain and review? In other words, we didn't send you down there to sit with Dan and listen to him. We sent you down there to obtain the records and bring them. To this day, we have not seen the records to justify how much we paid overage in labor to Metro. And there's other issues that I'm not going to go into. My 3 minutes is up. I'm sorry for going over. I'll answer any questions, anything. But if you're going to meet with that lawyer, I want to be at the meeting to offer my rebuttal.
Yeah, and thank you so much for sharing that story. And one of the things the lawyer had said is that, there's no issues, we're seeking, a problem. This committee gets hundreds of requests, and like I said, we got dozens of bill requests to tackle this issue. So it is not just happening in Rocky Hill, it's happening all over the state. And just tell us how these changes to statute will benefit everybody in the state. And you did hear about, I think, who pays for the audit. So if you can just elaborate on that a little bit.
Because of my marriage, offered to pay out of my own pocket a forensic audit of our finances at Westage. I gave money to Attorney Baird, who retained Steve Pednall. And it says that in 47-260, that an owner or their authorized representative can acquire and review records. I authorized Stephen Pednall to review the records at Metro. They refused to allow him access. They refused to allow me access, anybody associated with me, because we know what we're looking for. Now, I'm going to say this. There's a section of the law, 47-278. And I think if I do this right, I can read it to you. I'm nervous. The failure of the association to comply with the provisions of this subsection shall not affect a unit owner's right to bring an action pursuant to subsection A of this section. It says that if they violate any of my rights, my right to obtain records, that I should be able to seek retribution, not retribution, but compliance in the court of law. So Attorney Baird filed a motion for bill of what's it called? Bill of discovery. And the court said I didn't have standing. The board could do it, but I couldn't as an individual owner. I have evidence that the invoices said $430. It doesn't say labor or material or tax. And I am flabbergasted that I can't get that information, because if anybody in here has a technician come to their house to fix their washing machine and they use parts, you get a bill and it says labor, this is how much material, and this is how much tax, this is what you're paying for. I asked the board a question as the treasurer. Does anybody here know how much we paid for labor so far this year or last year's budget? Nobody could answer the question, because they didn't understand what they were reading in the statute. They didn't understand and had never read the bylaws. I did. I don't know how to explain it to you, but an individual owner who has evidence in his hand and has an accountant agreeing should be able to, without any question, file in court and get those records. If he doesn't want to go to court, just give me the records. Because I filed lawsuits trying to compel Westage and Metro to comply with the law, Arbella Insurance canceled the insurance for Westage condominiums, too many claims, and it's costing Westage now $170,000 excess premiums to get insurance. And what do? They go to the reserve account, liquidate it from like 190, 200,000 to nothing, and they paid the premium in a lump sum. Well, I sold insurance for a while. If you sell a policy on a monthly premium, you get your commission monthly. If you sell it all in one, you get one big check. There's something wrong with property managers. And I'm not saying it's every community. I'm not saying it's every property manager, but the only place we as owners, and you're right, I don't know, OLR could give you the information. How many condos associations are there in Connecticut? How many condo units in Connecticut are owned? And you can assume that it's either one voter, one taxpayer, or two voters and joint taxpayers. These are all people that Rachel Baird talked about me going door to door to get proxies. Hi, I'm Ed Peruta. I'm on the board of directors. I'd like to discuss the situation. They invited me into their homes. They told me their problems. And the one thing they said is, we need Dan Zach and Metro out of here. We want an accounting. That's how I got all of those signatures. Now, the new board is nervous because the reserves were liquidated. The condo fees are going to go up, and they're afraid that Dan Zach's going to sue them. I'd hate to be the first guy off the landing barge on Omaha Beach, but somebody's got to do it. I'm coming here and asking for your support, the legislative support, to tell the guy who represents the lawyers who represent the associations, you know, keep it to yourself, or I'll debate you any place, anytime over what's going on. And I'm not, there's a case right now out of West Haven, Connecticut. It's an 8-count lawsuit. It talks about civil theft, violation of the Connecticut Unfair Trade Practices Act, fraud, you know, and it's all there. Just change the name and it fits Westage. I'm sorry I took so long.
No, you're fine. Does this company, this former property manager for Westage, does this company also manage other properties around the state?
Yes, he does. And I believe there could be as many as 40. Now, we've made a complaint to the Department of Consumer Protection. There's an examiner on the case named Jill Conklin. And Jill Conklin, we heard from one of our board members who went to a church or social, who met the president of Lexington Estates in Rocky Hill, Connecticut. Lexington Estates, and I guess the president is Zoe something, used to be on Channel 3, but I guess she's maybe the president. Zoe Zeller or something like that. Okay, now, they said that they had a management company. The management company didn't want to do it anymore. So they had a name, and I'm going to say ABC Property Manager. Dan Zach started an LLC called ABC Property Manager Zach, a different name by one or two words, but everybody, and he took over Lexington Estates. Jill Conklin tells us that's illegal. You can't do that. You can't just take over somebody else without the process. There's things that are wrong, and the little guys are getting screwed. And I'm going to say this on the record. Mrs. Wood, you've known me pretty much all of your life. I've been in Rocky Hill. I've spoken publicly previously, but I probably haven't done anything like this in 15, 20 years. I kind of got out of it. I'm an old man now. I even got false teeth. So I'm just trying to say to you, I need support. And my support should come from black and white letters in a statute book that anybody can read and understand what they're supposed to do and what we supposed to do, etc. I'm done unless you have questions. Representative Barry, I'm just sorry that you didn't get to ask me any questions because you asked some good ones.
I was just going to comment that the last 15 years have been so peaceful, but
Yeah.
Thank you for sharing your story. Oh, thank you for sharing your story. I think you have answered all my questions, but I just want to make a comment that Steve Pednall is the best in the business and you're in good hands with him.
Well, they're debating right now because they're afraid of the cost because they liquidated our reserves. And I don't think they had the right to liquidate the reserves. A budget is a controlling document. It controls everything. You cannot simply walk in and take $190,000 out of the line items that say reserve and reserve paving and pay an annual insurance premium with that, leaving the association with no reserves. That's our insurance. That's our insurance for if something happens. And there is no documentation of a contract in Westage ever being put out to bid by Metro or the board. There's nothing. There's no notice to owners. It's a fiasco in there. And I have the support of about 71 people who have trusted me to represent their interests because I serve on the board.
And one last question from me. What are you doing differently as president of the board?
I'm not the president. I'm just a member of the board.
Just a member. Are you having this new board make sure that the records are kept and transparent? Are you putting things out? Like how can the how do you advise running the board than your previous board did?
We are all attempting to read and understand our obligations under 828, Section 47, under the declaration, under the bylaws. And I explain it this way to the members of the board and to our community. Think of the Connecticut state statute as the Constitution. And then you have a state US, and then you have a state constitution called the Declaration that's specific to your organization. Then you have bylaws, which are like state statutes. And I'm trying as best I can with the limitations that are placed on us. In other words, you're supposed to look for a new property manager start 6 months ahead of time. You're supposed to have your budget in place by January 1st, the first day of your fiscal year. We still don't have a budget, okay? And it's now March. And I made the statement to the board, look, we can't come up on July 1st, halfway through the fiscal year, and not have a budget. We didn't have an annual election until December 12th, because there's a provision that says if you don't have the election, the existing board members can go beyond their term until they're replaced. So they kept pushing the election so that they could stay on the board to give Dan Zak a $25,000 settlement over the 65-95 issue. And I said, that's right. You can take his money, but you cannot resolve him of a CUPTA claim. That's something totally different. You don't have the right, if he committed fraud or civil theft, you don't have the right to pardon him or to do whatever. You can't forgive him of that because the public, the people who live in the community, don't have any say. It's the board. And I got to tell you, the former president of our board was a tenant in one of his apartments. The secretary had a daughter that worked at the pool. When another member was paid by Metro to take up and down the flag and manage the pool. These people all had some ties back to Metro that they were, maybe it's legal, maybe it's not, but self-dealing, he does the snow plowing, he does the mowing, he does everything. And here's his one phrase. I'll get to it tomorrow. And there's something else you have to know. Dan Zak tells everybody at meetings, I have it on tape, I don't read or answer emails. I don't read or answer letters. You want to talk to me, call me on my cell phone or send me a text message. 828, Section 47 requires that they maintain all complaints and correspondence from owners about what's going on. I will be back or I will be in a court somewhere because Dan Zak is not going to have all of his text messages. That's a way to avoid scrutiny, is to do it by text message. So I could give you his background, but may I suggest that you Google Daniel Zak, the Hartford Current, late 90s, Siskey Google Shook, Colonial Realty, Hartford parking garages, indictments, just.
Thank you very much for being here. I don't see any more questions online, so we appreciate you and we'll be working with you on, fixes to the bill.
I have documents, I have testimony. You need answers, I can give them to you. And I think that this Jill Conklin is going to be a very good person to look into this.
Thank you.
Thank you.
Thank you, Mr. Peruta. Next up, we have Ryan Latrerio, followed by Sarah White.
Good morning, everyone. May I just confirm that you can hear me?
Yes, we can.
Thank you, and thank you for the opportunity to speak today. Ryan Lutrario from Savage Law Partners. I'm an attorney, and it's in regards to an opposition to Bill 7078, specifically would be Section 3 related to real estate wholesalers. And generally speaking, the opposition is based upon, at least in my opinion, my outlook, that it's a piecemeal approach to regulating an industry, and I don't think there's a significant benefit that would arise from it. And I'll go over that in a brief detail as well as follow up with questions. A little portion of background. I've been operating within the litigation and transactional world of real estate since about 2018 with a heavy focus and wholesalers. And I'd say wholesalers and anything of the like, whether that's individuals who are using assignments, listing on the MLS, utilizing the novation form of a contract or nominee. My experience during that time frame from 2018 till now is in excess probably of 1,000 transactions that I've facilitated, and I'd like to take the position, while obviously a court of law can review this, that my guidance with my clients in drafting agreements, reviewing disclosures, and providing proper means for these transactions has been above bar, and if anything, in conformity with whatever the Federal Trade Practice Act would come down on, or any future regulations that might come in the future. The opposition to the bill is not necessarily rising because of any concern as to a regulation in this industry. I'm of the forefront, being a business attorney, that every form of profession and industry should be regulated. However, my concern is with the approach that has been taken, and it's a focus on today's bill that's before you, but it's been numerous bills that I have reviewed in the past, and my concern has always been that it's not focusing on the right issue, which would be disclosures and ensuring that all parties are aware of the type of transaction. Granted, again, this is obviously my opinion, not necessarily the opinion of those that I'm speaking to currently. The first portion of the bill that focuses on what should be disclosed, and the reason I wanted to bring up my past and history in this field is that all of the clients that I work with have always abided by this process of disclosures. And I'm referring to subsection B that identifies the necessary disclosures by a wholesaler. My clients that I've represented have gone well above this point, actually, to the point where they have very detailed disclosures breaking down the fact of what the transaction is for the purposes of protecting a consumer and never being placed before, whether it be a DBR, an attorney general, and any future board that's formed in the New England area, as I'm not aware of any that have been formed in Connecticut, Rhode Island, or Massachusetts in order to regulate them. The second portion, and as I stated, I do not have a specific objection to a bill being presented that has disclosures, as it would actually weed out any of those individuals who are considered, as we call them, the bad actors, that they are not following a proper process and informing and updating and being transparent with the consumer.
Your 3 minutes are up. If you could please summarize.
Yeah, that's fine. The second portion of that bill that raises my concern pertains to the requirement of residential consumer or condition reports, which, in my opinion, serves no benefit to a consumer and essentially deters consumers from utilizing wholesalers, which I can elaborate if there's questions on it. I see a large benefit to utilizing wholesalers, not only for business, but also for consumers. And then the last portion that I raise a high concern with is indicated that there be a misdemeanor violation by the seller or by the wholesaler. And my opinion on that is experience in law in general. Misdemeanors are an item that raises to a higher level. This is a violation of a civil act, if it was litigated at this point. Being the Trade Practice Act, it does not give rise to a misdemeanor violation. We're looking at acts such as trespassing, DUIs, etc. And I believe that's going too far to an extent, and if anything, would again cause parties to entirely deter them from utilizing the wholesaling model. And thank you for allowing me to wrap that up. And I would greatly invite any questions on this item.
Thanks, Ryan. How often are wholesaling agreements being used in the state?
When you state how often a wholesale agreements, are you saying the form of a wholesale transaction or a contract that's
That's
considered
actually
a
better
wholesale
phrase, a
contract?
wholesale transaction.
In terms of percentages of overall transactions,
Yeah, do you have
1-2% of the transactions.
Okay. And what are the benefits of doing a wholesale transaction if you're a seller?
And if you don't mind, would I be able to provide an exact example that I've been involved in? Or obviously I'm going to give a beneficial side an example, but I would like to state that as well if you would allow. Is that okay?
Sure.
So I'll give you one example, then I'll talk about generally. The example that I have is I have a wholesale client approaches a seller. The seller is seeking to move forward, get out of the property. It is two elderly individuals, can no longer maintain the property, do not know what to do. When I say do not know what to do, it is very common these individuals do not know who to seek out as a real estate agent or anything of the sort. However, in this case, if they had gone to sort out anyone, as they had contacted, and this is from referral sources, individuals saying, don't use a wholesaler, use a real estate agent. And everyone came to the same conclusion. You have a severe title issue that we cannot rectify. You are absolutely out of luck. A bank is foreclosing on them. The problem is the bank had an error 10 years prior that actually left the bank as owner on the deed because they had perpetrated a foreclosure, but then entered into a forbearance agreement and a loan modification with these two individuals. These two individuals have been calling a bank for 5 to 10 years to the point where they're about to lose a home that they didn't have title to in their name, so they couldn't sell. A wholesaler was willing to enter into a wholesale agreement with them, have them obtain separate counsel, and then pay that attorney to facilitate a quiet title action to force the bank to transfer property back into their name. These individuals are closing in 1 week on a mobile home, which is fully refinished, and they're able to move in and they don't have to worry about taking care of a residence, changing the water heaters, going up and down stairs, and they'll be able to have that home for the rest of their life. My opinion on these types of transactions, which are many that I've done that are akin to this, if you're utilizing the right model and you're doing it, in my opinion, correctly. You're following a full, transparent, and candid process with the seller who's aware from the start that these individuals are not closing on the property. Some of them do. I will state that a lot of the wholesalers will close if they cannot find an end buyer. However, many times they are not. They're going to seek to assign, novate, and they make this very clear to a seller at the onset. And it's not only clear verbally, it's also placed in writing. And I know there's a concern with many of the wholesalers who, again, I stated earlier, the bad actors who approach individual sellers and do not fully inform them. They are just trying to get them to sign the contract. That is why I do still feel it should be some regulation. However, the benefit to wholesaling goes far and above any other means of facilitating a transaction for individuals that are in situations that they need further assistance. They need assistance to find suitable housing. They need assistance to pay upfront for that suitable housing. They need assistance with buying a house. And I have exact examples of wholesalers who have purchased their future home because they could not do a dual closing, a close on the same day to buy one and sell the other. They needed a close in their first house. So the separate house was purchased. They closed on their first house, and then they repaid what would end up being a mortgage for ownership of that second home. There have been many means that I have seen that wholesalers have assisted over the last 7, 8 years of me doing this, that have gone above and beyond what anyone else would do to assist these sellers. And I mentioned a few instances of finding suitable housing, filing legal action for them. But it's gone to the point, and I'd say the biggest avenue is the probate aspect, where a lot of times houses sit distressed for years upon years, and to the point where they're completely condemned and should not be lived in. However, obviously individuals still do. But the wholesaler has come in, engaged probate counsel, which is generally a concern on these transactions, and the individuals have sat on this home for years, who will then facilitate a probate in order to sell. And the wholesaler is the one paying it up front with the signed document as an addendum to a purchase agreement with the hope of being repaid when really they have no security. Because at a point, if that person said, I'm not paying you for the probate and I'm not going to go forward to sale, you have no mortgage, you have no lien, you have no security. So that's little tidbit of what I have seen in my career. I don't want to spend too much time because I give you numerous examples that are usually, in my opinion, the ones that are kind of pushed under the rug and not noticed. And I can say there's certain wholesalers that are very well known for the help that they will give to sellers. But if you go on a website and reviews, you will see consistent negative reviews because people do not want to be solicited, not because of what these individuals have done for sellers. And that is my outlook on the benefit that does go from the wholesale transaction. But if you have any further questions, then I'm free to answer as well.
Yeah, thank you for that, Ryan. So you're okay, if I interpreted your testimony correctly, you're okay with the disclosure part of the bill. You're just not on board with the rest of the recommendations, correct?
And when I said I am okay with, I am in agreement with having forms of disclosures run and overseen by a government body and administration, same as, we'll choose an easy example, the Board of Realtors, which we have within every state and actually within each county as well in certain states. I believe they should be further detailed. That is my only concern with it. I'm not necessarily opposing that portion of the bill, but in the sense that I am opposing that it should be more detailed than what is being disclosed and transparent to a seller. And I could state, and that's why I had indicated earlier, I do know my clients have very detailed disclosures in letting a seller know that they are a wholesaler, they are going to market the property. I cannot see how you can facilitate a transaction if you don't have those disclosures in a contract because you don't have the ability to do it. So yes, long and short is no objection to the concept of having wholesalers disclose. I just would have an objection if we don't have a determinative means of how it's going to be done with a body that oversees it.
Okay, and did you submit your recommendations in your written testimony?
No, but I can if you would allow after speaking to
you
them.
would send them to the committee or any one of us on the committee. We can get it around to the team. Appreciate that.
No problem. Thank you.
Any other questions? Great. Thank you for being here, Ryan.
Thank you very much for your time.
Next up, we have Sarah White, followed by Joanne Breen.
Thank you for the opportunity to testify today. My name is Sarah White, and I'm an attorney at the Connecticut Fair Housing Center. I'm testifying in opposition to Section 1 of HB 7078. Connecticut has prohibited self-help methods of eviction since colonial times, and since the 1720s required landlords to get a court order to regain possession of a rental property held by a tenant or another occupant. This bill would roll back hundreds of years of Connecticut landlord-tenant law by enabling landlords to bypass the eviction process and due process to forcibly remove and even arrest many tenants and occupants. I know how dangerous this bill is because I practiced law in a state where landlords could say tenants or their family members were trespassing and have them forcibly removed or even arrested without going to court or providing due process. The result was that tenants lived in constant fear and suffered incredible injustice because landlords had so much power over their lives and liberty. I worked at a legal aid office in Tennessee where around half of my practice was representing tenants. Self-help methods of eviction were illegal but commonplace and widely tolerated. I had tenants evicted by cutting off their water, shutting off their electricity, changing the locks, removing the front door, throwing out their property, and even threatening them with a gun. Landlords frequently claimed that any tenant or occupant they didn't like or had fallen behind on rent was trespassing and should be arrested. I represented a number of tenants who had defenses to eviction and decided to stand up for their right to a court process. But Tennessee had a process somewhat akin to the process in this bill, where someone could swear out a warrant and have a person arrested with minimal oversight and few safeguards. The consequences were that my clients were declared trespassers in their own homes and threatened with removal and even arrested. I have a number of stories in my written testimony, but I'm just going to share one of them. Ms. T lived with 2 small children. Her landlord told me he intended to burn down the mobile home with her in it if she did not leave. And that night she called me at 1 a.m. because her landlord was shooting at her home with a shotgun. She and her kids were hiding under the kitchen table and I could hear the shotgun over the phone. I filed a lawsuit and got a restraining order on her behalf the next day. However, her landlord used this process in Tennessee, to swear out a warrant against her for trespassing and allegedly damaging a curtain. She was arrested by police for trespassing in her own home and spent several months in jail before being released. She was too scared to pursue the lawsuit, and the last time I saw her, she had become homeless and her kids were no longer with her. Similarly, larger apartment buildings and subsidized complexes in Tennessee often use what were known as trespass lists to effectively banish tenants, their family members, and other occupants without going to court or any due process. These landlords kept lists of banned occupants who were often spouses, kids, family members, caretakers of the named tenant on the lease, and may have been living there for years. The landlords purported to unilaterally trespass occupants from the building for unclear, unarticulated reasons effectively immediately. They had total discretion to add people to the trespass list, and there was no way to get your name off. If you returned to the building, the police would be called and you would be arrested. Landlords used these trespass lists to bypass the court eviction procedure and basic due process protections for all occupants except the named tenant who signed the lease.
Your 3 minutes are up. If you could please summarize.
So this meant that large families, except for 1 or 2 people who signed the lease, were vulnerable to being thrown out of their home at any time at the mercy of the landlord, which understandably created a climate ripe for abuse and exploitation. People were scared to speak up about safety issues. And I know that Tennessee is very different than Connecticut, but I also worked at a legal aid office in Washington State and outside of the Seattle metropolitan area. Some of these practices were still going on there too.
Thank you for your testimony. I have to say that you really lost me when you started telling stories from Tennessee, and the unauthorized person definition in this bill is an individual who is unlawfully occupying real estate and who is not A, a current or former tenant, or B, an immediate family member. So I understand that you're opposed to the bill, but we're here talking about Connecticut. And I just wish that you would have stuck to that rather than sharing horror stories from another state.
So in my written testimony, I explained the problems with that definition and that it really is so broadly worded. It's immediate family member of the landlord, not of the tenant, for one, as it's worded. And the proof to show that you are a current or former tenant is a written lease. As we've heard, a large proportion of tenants in Connecticut, especially low-income people, have oral leases. It's also not uncommon to have other family members or roommates living in there who are not on the lease, or for tenants who have never received a copy of the lease. So while I understand that the intent of this law is to, perhaps create a narrow exception, it would swallow, the process that we do have and have had in place for hundreds of years. When there's not been a breaking and entering, when there's not been a crime, that a landlord does need to go to court to get an order for there to be a chance for everyone to be heard, which if you look, going back to the 1700s was about protecting, not just due process, but the safety of the community as a whole, because there was so much violence around, taking the law into their own hands.
Thank you. Any further questions? Thank you for your time. Next up, we have Joanne Breen, followed by Adam Devine.
Thank you for allowing me to speak today. My name is Joanne Breen. I am a past president of Connecticut Realtors, and I currently chair our legislative committee. Connecticut Realtors appreciates the opportunity to submit testimony in support of HB 7078. This proposal will do several things, which I'll summarize briefly. In Section 1, it does relate to a squatter's bill and a more expeditious removal of unauthorized persons from real property. And thank you, Representative Wood, for clarifying what the intent of this bill was. It is not directed at people that had any lawful right to be in a property prior or any family member. It is for someone completely unauthorized to be there in the first place. We have since had an opportunity to speak to the marshals before this meeting. And after getting some clarification from them on some of the difficulties they may have in removing people, we are going to be working with them to provide substitute language for this. So I'm going to set that aside for now and move on to Section 2. In Section 2, this is a proposal to change the minimum number of hours required for a real estate continuing education course from 3 hours to 2 hours, which may be all that's really needed to cover a topic. And very often instructors are stuck with having to sort of pad these courses to fill the third hour. This would not change the total number of required hours to get relicensed. It would simply change the number of hours per course. Also, the proposal allows for continuing education courses to be held in a brokerage's office. Right now, a remote course can be seen by agents sitting at their desk in their office, but a live course cannot be held. And we feel that this is a rule that needs to be modernized, especially since COVID, when many of our courses have moved to remote. And this would allow for a live course to be held in a different location. In Section 3, we are seeking regulation of real estate wholesaling, and I do want to stress that we are not looking to ban wholesale transactions. We know that there is a time and a place for these transactions and a need for them. We are seeking regulation. This is where an individual of an LLC or an LLC purchases the assignment rights in a residential real estate contract without taking ownership of the house. They then seek a buyer, and they're able to keep the difference between what they agreed to pay the seller and what the buyer is paying for the property. The sellers in these transactions are often elderly, or they're in financial distress situations, and they may have no idea what the full market value of the property is, nor do they realize the substantial equity that they may be leaving behind, often in the $50,000 to $100,000 range or even more. Currently, there is no fair housing training, no education that's required, no liability, and the potential for extremely high profits. We are suggesting a disclosure form entitled Notice to Sellers in a Wholesale Transaction.
Your 3 minutes are up. If you could please summarize.
Okay, thank you. The reason for this would be to clarify the wholesaler's intent to assign the contract to make a profit from the sale, and clarifying that the seller is granting the wholesaler the right to accept or reject an offer that may come in on the property. In Section 4 of our bill, that really is, we are eliminating that because there are so many housing study bills right now. There's really no need for us to ask for another study. And lastly, CTR is asking for a change of name to the real estate licensing from real estate salesperson to real estate agent because of the scope of work that we do that entails more than just being a salesperson.
Joanne,
So-
thank you very much for your testimony.
Mhm.
Can you share with us your request for the wholesaling regulation, why that is important to the Connecticut Realtors?
We feel it's important because it's very different from a standard real estate transaction. And the concern is that there may be sellers that get involved in these transactions that do not understand. We've had calls come into our office from sellers who thought they were entering into a standard real estate transaction where they were hiring an agent who would be working as their fiduciary. They thought they would still have control over who was going to, how many showings were going to be going through the house, when the showings were taking place, what kind of marketing, and that they would still have some control over the offers coming in. They didn't fully realize the difference between a standard real estate transaction and a wholesaling transaction. And that's why we feel there's a need for disclosure, so that it's very clear to the consumer exactly what the wholesaler is doing for them, what they cannot do for them.
Okay, I think there was a lot of consensus around the disclosure. I think it's some of the additional language in there that definitely brought up a lot of concern. So with that, I want to ask one final question. Can you explain your request for the salesperson versus agent change and why that's important to the Connecticut Realtors?
Yeah, I think, I started in 1978. I hate to admit it, but back in 1978, when we were working with buyers, for instance, we really were a salesperson. They were a consumer. We weren't representing them. Over the years, as you know, when buyer representation came in the late 90s, that whole relationship changed. We really are a fiduciary of everyone we work with, whether it's the seller or the buyer. So to refer to us as a salesperson is really a misnomer, because there is a relationship there where we are advocating, we are consulting. There are so many, we handle leasing, we handle sales. there are many, many things that we do that go beyond just selling the property. So that's why we feel agent is the more proper terminology.
Great, thank you for that. I just wanted to have that explained for the committee because
Mhm.
it's why the bill is so many pages, and I know it was a lot of work for our
Right.
legislative commissioner's office. Any other questions? If there's any online. Great, thank you so much.
Thank you.
Next up, we have Senator Bob Duff.
Good morning to the committee. Thank you for having me. I appreciate it. I know you've had a long morning already, so I'll be very brief. I just am coming here in support of Senate Bill 1386 concerning dog breed and insurance underwriting and evaluating the feasibility of establishing a penalty for misrepresenting a dog as a service animal. I strongly support Senate Section 1 of the bill, which prohibits homeowners insurance or tenants insurance policy from discriminating based on harboring or owning a dog of a specific breed or mixture of breeds. The reason I believe this is important because the data just doesn't follow what is sometimes practice, meaning that those who what people perceive as violence is not always actual, and insurance companies are then saying that you can't have a specific breed of a dog, which doesn't match up. But there is a lot of misinformation, as we all know, about certain dog breeds like Rottweilers or Pit Bulls or others. I have found them to be very lovable and kind, and many times would not hurt anyone. I found some other dogs that are probably not on that list to be at times a little more aggressive. So I think that this is a very subjective type of practice that is done by the insurance companies. And I will just say that the bill does not say that if a particular animal does injure someone, that policy cannot then change and prohibit that type of a dog for that particular policy, but that we should not have this broad-based ban. And I believe that there's bipartisan support for this. I've been working on this with Representative Nuccio, and that many of us who are dog lovers would like to see this become law. Thank you.
Great, thank you for being here today. Senator Cabrera.
Thank you, Senator, for being here. Thank you for your testimony.
Thank you.
Learned more about dogs than I ever thought I would during this legislation. I know Representative Nuccio has been lobbying me for a while about it. And I thank you for your advocacy on this. I know you have a dog or several dogs and some experience with this. And I was hoping you could touch a little bit upon your own personal experience and how this began to unfold. Because I think even for me coming to this issue, I did also have a bit of a stereotype and about what kind of dogs tend to be more violent than others.
Right, exactly. Thank you. It's funny because I'll just say this. I think that there's probably been more times I've been bitten or ankle bitten or finger bitten by smaller dogs than I have by larger dogs. Not that I don't like smaller dogs, but that there's a perception, again, that Pit Bulls or Dobermans or Rottweilers or others are dangerous, and they are generally very loyal and very lovable. And that we actually, my first dog that I got after when I moved into my own place was a mix, but she was part Pit Bull, and just a lovely, lovely dog. Played with other dogs, no problem, but fiercely loyal. Our second dog, Riley, was a Pit Bull that we adopted, and our kids were small, and I adopted her knowing full well what the stereotype was, but it was to send a message based on my own little bully pulpit that I have, that these dogs are good dogs, are kind dogs, they're generous in their love, and they wouldn't hurt a fly. So I think that, and it did, a lot of people like you were very much of, hey, you're right, these dogs are actually, they're good dogs. Now, I will say this, like people, any animal can be trained to do anything. And yes, I would say that Pit Bulls and Rottweilers and others, they're strong dogs. But they're not inclined to be a certain way. They're inclined to be a certain way if they are trained to be a certain way, which is why sometimes they're trained to fight. My dog, my current dog, Molly, was, I got her from the Westport Animal shelter and from WASA, and they found her in in the woods over by I-95 in Westport. She was abandoned, probably thrown out of a car. I mean, just awful. And maybe because they were trying to train her to fight somewhere, and that she wasn't very good at it. But all I know for her, for us, is that she's a lovable dog. She loves people. She loves kids. And pit bulls tend to be nanny dogs. That's how they're raised. That's who they are. And I use this example that there was one day I was walking her, and that there were these two baby carriages that were coming by. She would not move. She literally would not move until she poked her head into the two baby carriages to make sure those babies were okay. And she just poked her head in, she sniffed a little bit, and after that she was totally fine. But that's who they are. And so I just think that there's kind of this subjective nature of what we hear on the media without a lot of data behind it. So sorry for the long answer, but that's
No, thank you for sharing that. It's important. I too came with all kinds of prejudgments and so on. I don't know why my brain is remembering. I don't know if it was Truman or Roosevelt said, if you want to, talking about politics, if you want to offend in politics, get a dog.
A dog in Washington. Yeah, I think that was Truman.
So I've learned a lot about this issue. So I really appreciate your advocacy and sharing your stories with us today. It means a lot. And it helps us make a clear decision. Thank you.
Thank you.
Thank you, Senator Duff.
Thank you.
Next up, we have Adam Devine, followed by Robert LaChance. Just press the button yep, perfect.
There we go, much better. Hello, everyone. Appreciate you guys having us today. Rep Wood, Rep Barry, Senator Cabrera, Adam Devine, Managing Broker, Dorrance Realty, and founder of PerTruck. I am in opposition of Bill 7078, Section 3. All of the items that are referenced there are already completed and actually required, which wasn't mentioned for every transaction. 6 months. I couldn't tell you the last time I've seen any wholesaler in any part of the country do a 6-month purchase agreement. You're purchasing a home quick. It's typically significantly less than that. I don't even think I've seen anything at 60 days, but I would oppose that. The disclosures, anytime you want to do any type of, as we call, assignment of contract is the legal term for wholesale. An assignment needs a requirement in the actual purchase agreement. So whenever you're going to go try and assign an agreement, it already has to be written there in order to disclose and complete that transaction. So in order to go ahead and fulfill that agreement, if it's not written there, you can't wholesale or assign it anyway. So I would oppose that. Same with disclosures. We're buying a home from a seller, folks that want an easy and simplistic transaction, right? They don't want to fill out a condition report of their home. If anything, if they do that, there's a likelihood they can go back and disclose something or something's noted to then further negotiate that deal. If we're buying a home, we promise to make the transaction easy and simple. That's why they're coming to us. They're voting with their wallet. They're voting with their decision. They're choosing the little guy over the big brokerage because they want ease and simplicity. We're not a one-stop shop where we have a one-trick pony if we can list your home for 6% plus all the hidden costs and fees that come with a realtor's listing agreement. We're very simplistic. Hey, no cost, no fees means no cost, no fees. Okay, maybe that doesn't work. We take another approach. There's several different items that for us at PerTruck we're able to provide folks, and we've done it for many years now. So we are in opposition of this bill. I welcome any questions that you may have for me, and thank you.
Thank you, Adam. Can you just elaborate on the you negotiating on no cost, no fees? Does that mean that you would cover like closing costs and other things for?
Yeah, it's a great question. So to answer that in short, the answer is yes, right? If we tell a seller in a transaction, we have a conversation with them, depending on how many touch points there are in that agreement. Before we enter a written agreement, in the state of Connecticut, we're not a title state, we're an attorney state. So there's going to be an attorney for the seller, there's an attorney for the buyer, and there's usually an attorney for the wholesaler or the assigner. So if we tell you that there's no costs, there's no fees, we're going to cover your conveyance, we're going to cover your seller concessions, your sale tax, your attorney fee, any repairs that come up that are needed for the property. We're covering everything. I mean, I know there's no realtors that can do that, but for us, we'll happily go above and beyond. We actually closed on a home yesterday in Milford. We bought the home. We did $17K worth of repairs prior to closing to sell to the end buyer. We actually bought another home for the seller to relocate to because she didn't have the funds. And come to find out at the close, she actually owed an additional $13,000 that we covered out of pocket for her. So when we talk about no cost, no fees, we are going to go above and beyond if that's what's agreed on. Now, let's say we don't agree on covering the attorney fee or covering the conveyance tax. Then that conversation's had and it's in writing. Right? It's very easy and simplistic to do this business the right way when you just put things in writing. When I hear the bad actors and things aren't disclosed, it's just not true. I mean, us at PerTruck, we haven't had the issue. We sat with the Connecticut Realtors on several occasions. They stated the amount of complaints they had were very minimal. We sat with Jill Conklin this summer and spoke with, I believe it was Mercedes, who's the assistant AG. The complaints for wholesalers per se, I hate that term, by the way. We're a marketplace at PerTruck. It was very minimal. So it gets to become a question of, is this a load-bearing fiction of a falsified narrative being pushed, right? Who are the bad actors? I mean, we'd love to know. Let's get them out of the industry, but let's know who the name is. We'll let every attorney know. We'll let agents know, because now you can exploit the people that are causing the harm. But we don't believe it's as bad as it's being portrayed. We hear it typically, it's an older person, financial distress, and average salary we see is about 49 years old. We have the data. Average profit margin, $12,000 for an assignment. Last year at Perch, it's for us, we did it at 19. I mean, I have the data. Our fix and flip, 46,000. So I hear 50 to 100 on regular. I have to scratch my head because I haven't seen it.
Yeah, and just, in full disclosure, we as members of the Insurance and Real Estate Committee have received 0 complaints, regarding wholesalers. So, while we're open to solving problems in the marketplace, this is just a public hearing to kind of hash out, if there are problems, where things can be fixed, what we can do for the best bang for our buck with any statute language. So, thank you for saying that. And do you know of any, complaints or bad actors and where those would go to? Because I'd like to try to follow up to learn more about, who is complaining and where those people are.
Sure. Go to the Department of Consumer Protection, where we know firsthand complaints are sent to, just like any other bad actor. One key factor I found real interesting was that Jill Conklin mentioned there were only several complaints, and she has complaints all the time. So we said, well, Jill, if you're getting complaints all the time, who are they coming from? Well, it's in the regular, real estate transaction, realtors, buyers and sellers. Okay, so what are we doing about those bad actors, right? What's good for the goose is good for the gander. And for us, our concern is, the realtors say that they don't want to oust our industry, but if you look at the bill from last week, their actions speak louder than their words, and in fact, they do, right? And we've heard that from other folks through conversation that is the narrative. That's the truth. We're less than 1% of transactions in Connecticut. This is my livelihood. This is how I support my family. I don't even believe we're even at, I think the answer was 0.7 or 0.68 of total transactions. I mean, we're not even a fly on the wall. So when we hear the narrative being pushed that we're causing these big issues, go to the DCP, go firsthand. Let's get the facts. I mean, for us, we're all for doing what's best for everyone. Let's do what's best for the consumer, because ultimately the consumer wins, right? They're going to choose with their decision making, right? Coldwell, Keller, billion-dollar companies. Why are they choosing to work with us? It's almost Blockbuster versus Netflix. It's who's transpired to evolve in the marketplace and solve the real-time consumer need, the problem at hand, versus eliminating and ousting competition for monopolization. I mean, consumer can go wherever they want, but in terms of penalizing people, they can go to the DCP firsthand. They can go to the AG firsthand and put a complaint, and that can be taken up, and it can have further legal action against whoever that complaint is for.
Thank you very much for your testimony. Any questions? Great. Thank you, Adam. Next up, we have Robert LaChance, followed by Connor Reck.
All right, thank you for having me. Appreciate it. I'll keep this short and sweet. I know Adam spent some time, and so did Mrs. Breen there as well. I'm in opposition of Bill 7078. We were here last week, so and this is usually not my forum here, but the reason why I'm in opposition is it's getting clear. The more we work through this, it's the CT realtors looking to eliminate competition. It's getting very, very clear to me. I've been in this business for 20 something years, 51 years old. So a lot of different businesses, and this stuff is just getting clearer and clearer, but I'll stick to this particular bill and why I'm in opposition with it. There's 5 main bullet points I want to touch upon. First is, I know we talked about a little bit about disclosure. 3 things: intends to assign, doesn't represent seller, and intends to market. We do all of that already. So that checks the box. Not sure why that's in there. I would just, like the CT realtors to do a little more research on our industry. So then, we're not sitting here, fighting a bill or a section that doesn't need to be in there. Number 2, any seller needs to provide a wholesaler a written residential condition report. To me, that doesn't make any sense because that's more of an anti-consumer bill, because sellers should be able to sell their house as is and not fill out anything. So that, to me, again, that one doesn't really make much sense to me. Number 3, any real estate wholesaler shall provide the written residential condition report to the buyer. Again, buyers that buy properties understand what they're buying. If they're buying as is, they could hire an inspector to go check out the property. So again, more of an anti-consumer part of that section, if you ask me. Again, it's just my opinion. The 4th one is disclosure to end buyer about what is in basically the purchase agreement. We do that anyway. Again, there's 3 attorneys typically that are attached to all of our transactions. So, I mean, if 3 attorneys can't figure this out and say what they're buying, I mean, that's pretty standard in our industry. And then finally, the misdemeanor, Class A misdemeanor. I mean, when I saw that in there, I thought I was on candid camera and I was getting punked, because Class A misdemeanor, I mean, I Googled what a Class A misdemeanor in Connecticut was, and inciting a riot, larceny, prostitution. I mean, that's a little, extensive. So, I mean, individuals that are looking to get into real estate, are they either going to say, hey, I'm going to get into real estate, or start a prostitution ring? I'm just joking. But my point is, it's kind of extreme when you start looking at that stuff. So, that's pretty much what I have.
Yeah, can you just talk about the your opposition to the disclosures, because you're buying, or you're not buying, you're transacting a situation, it sounds like, where people may not have any other options. We just, heard something about a, bad title. But I can imagine that, sometimes people are trying to move property that, their septic is super old. They may have a roof that's aged and lots of other things. So if you can just explain why you're in opposition to the disclosures.
I just know, as an investor doing this for 20 something years, that it's my job to do my due diligence. If I'm going to purchase a property that I know maybe it's in probate and there was a hoarder, or it's my responsibility to hire an inspector to go check out to see what's wrong with it. I just think that's buyer beware. I know, and again, this is just my opinion. So, I've been doing this business for a long time, and that's what I've seen.
Yep. Any other questions? I don't see any online. Thank you so much, Robert.
Thank you very much.
Next up, we have Connor Reck, followed by Joseph Fiorella.
Hello, good afternoon to the Chair, Senator Cabrera and Representative Wood, Vice Chair Representative Barry, and members of the Insurance and Real Estate Committee. My name is Connor Reck, and I'm here today on behalf of the Insurance Association of Connecticut. Thank you for the opportunity to provide comments on Senate Bill 1386. The IAC stands in strong opposition to this bill, which would enact a modified version of the Model Act issued by the National Conference of Insurance Legislators concerning dog breed as an underwriting factor in homeowners insurance. Dog bites are common and can occur from any breed, which can result in skin and soft tissue injuries. However, multiple studies have shown that attacks by large, muscular breeds such as pit bulls can result in more substantial injuries, including death. A 2011 study from the Annals of Surgery concluded that attacks by pit bulls are associated with higher morbidity rates, higher hospital charges, and a higher risk of death than are attacks by other breeds of dogs. A 2018 study from the International Journal of Surgery Case Reports discovered similar conclusions on pit bull attacks, noting further that immediate surgical exploration is required to prevent catastrophic outcomes, especially limb loss. It is important to note that not all insurance carriers consider dog breed when underwriting a homeowner's insurance policy. The market is quite diverse in this regard. Homeowners have the ability to purchase insurance from scores of carriers, and this competition helps to lower premiums. If this legislation is enacted, insurers will be limited in their ability to consider dog breed as an underwriting factor, thus causing premiums to increase for carriers that utilize this category in their underwriting practices. As a result, non-dog owners will be forced to pay more in premiums to account for such underwriting limitations. If it is the intent of this committee to pass this legislation, we would recommend amending the bill's language to adhere to the Model Act issued by NCOIL. Specifically, we would ask you add the word solely in line 23 in between the words policy and on. The word solely is already included in line 5 of section 1 of this bill, and section 2 should reflect this inclusion as well. If it is the intent of this committee to effectively require all homeowners insurance carriers to cover all dog breeds, then we ask this committee to allow carriers to defend such claims. Current injuries sustained from a dog are a matter of strict liability when they are litigated, according to section 22-537 of the Connecticut General Statutes. This standard presumes that the dog owner is liable for any injuries caused by the dog, with the only outstanding question being what level of damages should be awarded to the injured party. We ask that language be included in this bill to change this legal standard from strict liability to a negligence standard. This revision would allow insurers to defend these claims. It is only equitable that insurers be able to defend if they are forced to cover. Thank you for considering these comments, and I'd be happy to answer any questions.
Thank you. You did answer my question, that you would be in support of the NCOIL model, correct?
Yes, it should be changed because section one of the bill already has it. So, and section 2 covers a similar topic, obviously dealing with dogs that are for deaf people and mobily impaired people, but the word solely isn't included in that. So if it's going to be in section 1, it should be in section 2.
Okay, thank you.
You're welcome.
Any other questions or comments? Great, thank you, Connor.
Thank you.
Next up, we have Joseph Fiorello, followed by Chris Bracken.
Hi, Joe Fiorello. Can you guys hear me all right?
Yeah, we can. Thank you.
All right. Thanks for the opportunity to speak today. I want to speak about the bill relating to wholesale real estate, section 3. I believe it's bill 7078. So I own a real estate company. I'm a real estate investor. I'll just kind of give you a breakdown of our business. We get a lot of referrals from attorneys, from realtors. I have a TV commercial, billboards. We get calls from homeowners who want to sell their properties quick. They don't want to go the route with the realtor. They don't want to pay the 6% commission. They don't want to do a ton of showings. They want to be done with these properties. They're problem properties. So we then buy them, we flip them, we keep them as rentals, we fix them up. Sometimes we even assign them. So relating to this bill, there's a couple things I want to point out. Number one, the disclaimer section where they want to have a disclosure for wholesale real estates. Section B, intends to sell or assign such wholesaler agreement for a profit. There is no such thing as a wholesaler agreement. It's a real estate contract that you can assign. Wholesaler is not even a legal term. It doesn't even make sense. Intends to sell or assign such wholesaler agreement for a profit. It literally it does not make any sense. I want to speak to the disclosure section. So what the realtor is saying is this is for the better of homeowners. To require disclosures for a cash transaction, it does nothing except expose homeowners to more liability. These properties are being sold to investors who are bringing their cash deals. Investors know what they're buying. They're savvy. Why are you going to increase the legal exposure of homeowners by requiring them to disclose or not disclose problems with the property? It's literally just going to hurt homeowners even further, and it's just going to give them more legal exposure. Again, I just think the real the real purpose of the bill is to try and put wholesalers out of business, and it's not for the better of the of the homeowners. And lastly, the misdemeanor. So like if you read how the bill is written, it says if you violate the bill, whether it's the disclosures, whether it's providing disclosures to the end buyer, you're gonna give them a misdemeanor. Like it's absolutely ridiculous. I think it's really an attempt to, limit the marketplace and require homeowners to sell through realtors. And to be honest, it doesn't make any sense at all. So I love, if you guys have any questions, I'd be happy to answer. But it doesn't make sense.
Thank you, Joseph. We did ask a lot of questions to other wholesalers and their attorneys that were here. So I'm pretty good on it. We hear what you're saying and are definitely going to work towards, resolving a lot of the issues that you have brought up. Any other questions? Great. Thank you for being here, Joseph.
Thank you. Thank you.
Next up, we have Chris Bracken. Chris Bracken, you're up. While we're waiting for Chris, is there any other people wishing to testify in the room? Chris Bracken, you're welcome to testify.
How about there? Can you hear me now?
Yes, we can hear.
Oh, perfect. Oh, great. Thank you. Can you see me? At least you can hear me.
We can't see you, but we can hear you.
All right. So I'll start. Thank you very much for having me in on this important session. I'm coming at this from a little bit of a different perspective in regards to disclosure, and I think that's the major umbrella of my input into what you're trying to work with here. And I did put some written testimony in. I'd ask that you please read that. I listed my status as opposed to this bill only because I don't think it carries enough weight for what really needs to happen with common interest communities, homeowners associations, et cetera, for which I am a resident of for 27 years. And I'm finding a lot of issues that I came to learn firsthand 27 years ago when I bought my home that are still happening today in my particular situation. And there's a common thread that's going on through these transactions. Buyers are buying homes in HOAs and they're not getting full disclosure. So if I come back to disclosure, my point is this. When I bought in 1996, 97, all I was told was it's a private association. Here are the bylaws. They plow the roads. It's $1,200 a year. Great. We had 2 realtors on the transaction. We had 2 attorneys on the transaction. We had the seller on the transaction. No one gave me the forensics of what I was getting involved in. When you are a seller of residential real estate in Connecticut, you file a disclosure record or report, which is a binding document that holds you responsible for any omissions in the disclosure of the property condition. When you are the HOA, and I'm in a 11-unit residential neighborhood, the HOA may not be bound, and I'm meeting with attorney Chaz Ryan tomorrow to go over this. He supports not putting too much burden on HOA board members, but he does want to hear my ideas for remedies. One of which is when you're an HOA, you don't have to put those disclosures to the buyer. So I bought my house, I come into this HOA, and all of a sudden, what really has happened is I've become a financial partner with 11 other residents in a situation, a geographical, demographic situation that I know nothing about. And the fact that things weren't disclosed to me, if they were, I would not have bought my home in this association. To that point, Margaret Muir, who is a leading realtor in Madison along the Connecticut shoreline, decades of experience, she's the go-to. I've done some work talking to a lot of realtors, but Margaret said something very poignant. She said, Chris, homeowners associations can be dark places and they would benefit from more transparency. Right? I live in a dark place. I had another realtor, Betty Zolshan, say to me, Chris, I have a client who will love a home in a homeowners association. They'll walk away because they know about the problems, the infighting, the issues. The bill that you're looking at today is a mismanagement of funds. I don't know if I have that going on, but to speak to this committee and the insurance committee, consider this one point. I have a home, and I have a $3 million umbrella policy on my home. I believe there are exposures due to negligence of the association that I live in. I've talked to my insurer, State Farm. They will not write me anything more than a $100,000 rider to cover me in the event of issues or omissions or acts of the association, which I am a part of. I don't want to be a part of an association where there's alleged negligence or deceptive practices, fair trade issues. And I'll jump ahead 27 years. I have a buyer who just came into the association. She has said, I would not have bought a home if I knew what I knew now. I have another buyer within the last year said, Chris, I didn't even know it was in a homeowners association until I was at my contract closing. So I would implore you guys to pull back, take a look at my documents. Yeah, it's kind of a horror story situation, and it's interpretive. One problem for me may not be a problem for another individual. But as a consumer, and this is really where I can remediate this within myself and hopefully for others in the future.
If you could please summarize.
Yeah. So no one is coming to me as the homeowner in this organization. I'm the senior resident there. Say, hey, Chris, tell us about the neighborhood. Tell us what it's like to live here. Tell us about capital projects voted up or down. Tell us about climate. Tell us about icing, water, plowing, road maintenance. Just last week, the president of the association sent out a memo about melting snow on a hill. Well, we have a severe icing issue, which is a water table issue. It's a groundwater issue. It's been looked at by engineers, and it's a six-figure fix. And the association doesn't want to fix it. Why should a homeowner come into an association and not be given this info? It's wrong. And it's the state's duty. You want to protect consumers, you need to protect consumers on purchases within homeowners associations. Because what I have seen and what I continue to see is extremely disheartening, disappointing. And the people who come in, they've signed their deal, they bought their home. Oh, by the way, did you know? No, they didn't know, because it's not mandated in any statutory language that the realtor, the lawyer, the seller, they don't have to disclose anything. So I would suggest you really, if you could, take a big step back, look at my testimony that I've submitted, and I'm happy to come up in person. I'm happy to come up and meet with you. I've done a ton of work on this. I've got a ton of people that I've spoken with. And I may not fix my individual situation. One person said, and I've got a great attorney, said, well, Chris, you can move. Well, I love my house. I love where I live, or get on the board. Well, that's not fair. Get on the board, because if I get on the board, I'm supposed to be able to duly influence the discourse by being on the board. I can't do that. That's not fair. We had a president of our association who had an IRS lien on his property. And when I brought up issues that I thought were important for the good of the community, he would skew the conversation away from that topic because he couldn't financially manage it. He even said, well, I don't have the money that you do. And so there's so much gray stuff going on with these HOAs.
I hear you. Thank you. I wanted to ask though, what is your opposition to this bill?
What is my opposition?
Yeah.
My opposition is that through Representative Parker, who's been great on hearing me on all these matters, he has aligned me with this bill and your committee as it is relative to my claims. My opposition is if we're going to write any legislation about disclosure and or HOA matters, to pull back a bit and get more data, have more hearings, get more testimony. Let me get my people involved and let's expand the bill to protect consumers. That's my opposition. I don't think it goes nearly far enough. And I can't even opine on the legal ramifications of what you've been talking about. I don't have a legal background. So
this is the vehicle for you to make changes and help people in situations like yourself. So we need you to reach out to us following this with some suggestions for improvement. You are the first person to say this doesn't go nearly far enough. There was a lot of testimony saying that this may go too far. We've had a lot of people send emails that they think this places an undue burden on association reserve accounts. So please follow up with us with your recommendations for what we can do better here, because this is the vehicle to do so.
I will, and I'd ask please first start with what I've sent, and I will follow up with some direct communications to yourself. I'll copy John Michael Parker and others on the committee as necessary. I can put those bullet points together for you.
Yes,
absolutely.
Please. Thank you so much for testifying.
You're welcome. Thanks for having me.
All right.
Thank you.
Any final comments? Great. Thank you, everyone.